Hey, good morning, everyone. This is Dan at Unicorn Riot. We're waiting for court to come back in. It's almost 9 a.m. Thank you all for joining us. We're live now on Facebook, YouTube, and Twitter. So thank you for tuning in. I'll just mention really quick, if you want to check out our website and share our work, unicornriot.ninja, the Gunpowder Trial landing page is right up there. We've got a new post about community members crafting messages of love for Daunte Wright's family outside the courthouse. There is a video with that, so you can check that out. Again, please share our work. That really makes a huge difference. We're not a huge corporation, and we do need the help with distribution. As available, we will have trial updates on Unicorn Riot Live. Check that out right there. And day to day, like we're a small group, so we don't always have the capacity to be on top of every step of this thing, but we are trying our best to push those updates out there. And we're a nonprofit media organization, so if you can support our work through the donate button up there, that is much appreciated. We really can only do this because people really, strongly support our work. So look, looks like we got a minute here. So if people want to sound off where they're watching from, we can definitely have sort of a check-in with everyone. It looks like we got about 70 folks on Facebook, and we're starting to get people on YouTube. I can't see how many. And we can see people moving around in the reflections of the plexiglass, so court should start quickly. If you want to talk about where you're watching from on the chats, you're welcome to add that. I can try to read it off. Besides that, we believe that this may be the last day of the prosecution. We're expecting someone from Daunte Wright's family to talk about what they call a spark of life. So, hello to Oregon and Minneapolis and Scotland, watching from overseas. Lancaster, Pennsylvania. Coon Rapids, Minneapolis 3rd Precinct, South St. Paul, Minnesota, Missouri, Arizona, Harrisburg, Pennsylvania. Thank you all for tuning in from all over the place. Really appreciate it. Okay. Connecticut. Hello, Connecticut. What else we got? Over on YouTube, someone's watching from Pittsburgh. Pittsburgh's a beautiful city. Let's see, what else we got? New Hampshire, Crystal, Minnesota, City Center, Minneapolis. So we got some people watching from all over. Deer Isle, Maine, Brooklyn Center. Let's see, what else? Plymouth, Minnesota, Frogtown, St. Paul. Hello, Frogtown. Florida. Hey, from Texas. Portland, Oregon. Where else we got? Indiana, Southern California, Longfellow, Minneapolis, Burlington, Vermont. Over on YouTube, we got the Atlanta users from Atlanta, Georgia. True Seeker from Massachusetts. Another person from Florida. Someone who lives 2 minutes from where this all happened. Someone's living in the gorge up the river in Portland. Ruth from Rhode Island. Philly, Pennsylvania. Hey, Philly. Crystal, Minnesota forever. Good morning from Albany, New York. Northeast, Minneapolis. Savage, Minnesota. Los Angeles, California. From the western slope of Colorado. New Hope, Miami. Where else we got today? "20 minutes from J.R. Ewing's house. Columbia, Fayette, Missouri. Richfield, Minnesota. All right. So, let's see what else we got. All right, let's all try to be respectful in the chat. If we're gonna start insulting people, We're gonna have to mod this stuff. Just try to like stick to the facts of the case. I think the chat can be really helpful, honestly, because there's a lot of different facts that go on, and we can all sort of help each other learn about what's happening. So, you know, just don't spam the chat. Just try to be respectful. Or we got someone else from Philly, so we got multiple Philly people here on the chat in different channels. Let's see what else we got. People are agreeing Portland is beautiful. Well, anyway, again, you know, we're waiting. This could be the last day of the prosecution. Someone else says that they live where they shot Brian Quinones. Believe that. Someone says hello from Maryland. Tim says hello from Maryland. So yeah, we really appreciate it. It's great to be able to reach folks that are, you know, all over the place. Try to like get across a better understanding of these important social issues. Good morning, y'all, from Chantal in Mobile, Alabama. Irene in Ontario, up there. Did you folks know that, like, I think most Canadians live south of Minneapolis, technically? Isn't that amazing? Like, Minneapolis is so far north that most Canadians live south of it. That is shocking. Anyway. Someone's watching from Charlotte. Good morning, y'all. Houston, Texas here. What else we got? Over on YouTube, LA all day, DC, North Carolina, St. Louis Park, Minnesota. Yeah, and again, you know, big ups, Verpqua, Wisconsin. I didn't know that one. Again, yeah, let's try to keep it, you know, respectful in the chats. Let's just try to, you know, stay focused. Like, even if you have, like, you know, personal feelings about whoever, let's just try to, like, try to understand what's happening in this case, what legal things are in play. And again, you know, don't feed the trolls. Just put brackets or whatever to kind of flag if there's trolling and whatever. All right, so let's see. We're waiting. You know, you never know when the judge is going to start. So, hello to New Brighton, Minnesota, Bethlehem, Pennsylvania. What else we got? Our person from Canada is watching from north of Minneapolis, not like some of these other Canadians. All right, so we're just, you know, we're waiting here. Okay. All right, I'm going to, let's see. If you just give me a moment. I think we're going to go to the press conference from the Daunte Wright birthday celebration. So I'm going to run that for a little bit, and hopefully the judge will come back before too long. So I just wanted to be ready because, you know, sometimes they come starting out right away, so I wanted to make sure the feed was up. Let's see, Seaside, Oregon in the house, Cross Lanes, West Virginia. What are other people watching? Anybody else? Anybody else want to speak? Someone says they've never seen so many Oregon people watching, and it's early out there too, right? That's 2 time zones ahead too. Miami, Florida, and Philly over there on the YouTube. Thank you for tuning in. So, all right. Yeah, we did hear Derek Chauvin changed his plea to guilty in the federal civil rights case. That was a new development in the Chauvin trial, or in Derek Chauvin's, you know, journey through the legal system, who was the man that was a Minneapolis police officer who killed George Floyd. So, all right, it's just after 7 a.m. out on the West Coast, but they're saying they show up because Black Lives Matter. That's cool, and it's 10 over on the East Coast. So we're, you know, it's cool. We're hearing people from Europe, from Canada, from the East Coast, from the West Coast. So thank you all for tuning in. We do, you know, we really appreciate it. It's really appreciated. So let's see. What else? All right. I'm gonna put up the presser from that birthday celebration that was pretty recent, and then we will. Let's see. We will. Yeah. I'm sorry. We will go live. You know, as soon as the judge comes in. Again, we are thinking this could be the last day of the prosecution's case. They may kind of, rest their case, and then it could switch to the defense. The defense could move quicker than we might expect. This whole thing actually has, in some respects, moved along pretty quick. I guess we're expecting to hear Brooklyn Center Police Department Sergeant Mike Peterson go into cross-examination. That is my understanding of the next witness. But there could be motions. We'll be ready if there are motions heard as well. We haven't heard any motions. Someone's asking if we can go to the Chauvin trial and Derek Chauvin proceedings. It's important to realize federal court does not have video access. And what we saw when we covered the Charlottesville trial, I went down there a few times. My colleague Chris was down there. So you can learn about the Charlottesville trial, which is that other banner link. I'll just pull it up quick. If my browser would work in the thing, which it doesn't. Okay. Anyway, we covered Unite the Right on trial, right? And that was a federal trial. And you could call in by the phone, but it was like illegal or the judge was forbidding anyone to kind of rebroadcast that audio or even really record it, supposedly. So federal trials do not allow video access. The Supreme Court does not allow video access, even though they do post, oral argument audio. Courts and their access are very restricted, right? It can be very hard to see what's going on in a courtroom unless you show up, unless you happen to show up. And with COVID, it's even harder than it used to be. So we can't have a direct access to the Chauvin trial. Sometimes judges have a phone number available. Sometimes you can listen in on the phone. With the trial in Charlottesville, the lawsuit trial against the white supremacists, you could at least call in on the phone, and it seemed like that usually worked. And then the press overflow room, from what I saw, had a video camera. I was there. It was very fuzzy, didn't really quite work right. So court access is very limited compared to what you get with the legislative and executive branches of government. And to what people are saying, I tend to agree. There should be more transparency in courtrooms, especially when you look at other forms of government. Video technology, as you can see, it definitely exists. They could certainly, tax lawyers to pay for better video cameras and systems in courtrooms. That's a great question. There could be, there can be phone numbers for courts. When we were working in Charlottesville, we looked around and the court website for that judicial district had phone numbers for judges. So, I have a little more info about that. One second. The Derek Chauvin hearing is at the Warren Burger Federal Building in St. Paul, which I believe is across the street from is it Kellogg Square. It's near the bridge. It's right by. It's not too far from Kellogg Boulevard, I should say. It's right off Kellogg Boulevard there, near where the TPT TV station is. Oh, all right. You'll have to give me a second. We got a technical problem, folks. Hang on.
Hello, everybody. Today we gather in Brooklyn Center, Community Center, to celebrate Daunte's 21st birthday. While we're celebrating memories and happy times when we should actually be celebrating him here with us. Unfortunately, Brooklyn Center police failed us, and that's why we're here today celebrating his memories.
Any other Daunte Wright's family want to say anything? Okay.
Hi, everybody. I'm Katie Wright and Aubrey Wright's sister, Naisha Wright. I do want to thank everybody for coming out here and showing my family support because we really do need it. Again, we want to make sure that we get some type of justice for my brother and my sister because they should never have to view their son, excuse me y'all, could y'all spread her real fast? They should never have to come home to see their son like this, as well as that beautiful urn. They don't deserve this. We're just asking for some type of justice and just support. We really need the community support. And whatever y'all can do, please do. Whatever you can say, please say. My brother and sister should not be going through this. These are some of the most beautiful people in the world, and the children that they have created. My nieces suffering, my nephews suffering. We just ask if we can get some type of justice and continue the support.
All right, so this is live. Thank you for joining us, everyone. We're coming into day 10 here. Appreciate your support, everybody. Please stay friendly in the chats. Thank you.
Okay.
We should have audio. Sorry, we should have audio. Hit the wrong button. Thank you all for joining us. We're coming into day 10 here. It's Kim Potter on the right. Her defense attorney is
Okay, good
Earl Grey in the
morning.
center.
Please be seated.
Paul Eng on the far side. State on the left.
All right, Mr. Eng, you may cross.
Morning, Sergeant Peterson.
Morning.
My name is Paul Eng. We met once before. I have some questions for you on behalf of former Officer Potter.
Okay.
You started your testimony yesterday by discussing why you became a trainer.
Yes.
And one of the reasons you mentioned yesterday was that you wanted to be safe.
Correct.
Safe meaning your own safety, correct?
Mine and that of my partners.
And you wanted your your fellow officers on the street to be safe.
Yes.
And you also wanted to be wanted the community to be safe that you serve.
Yes.
Okay. And specifically, you've trained officers so that you can trust what they do in times of need, your need, the needs of other officers as well. Is that correct?
Correct.
You're training them to make a split-second decision
Yes.
in what can be very dangerous circumstances.
Yes.
And you're training them to, if you were at risk, that you would want them to be making an instant decision on your behalf. Is that correct?
Can you repeat?
You'd want them to make the right decision for you if you were in harm's way, right?
Correct.
Which is a key motivation for you.
Yes.
And the purpose of training is many things, but one of the reasons you train is that police work is risky.
Correct.
You're dealing with a public that sometimes can be very dangerous,
Yes.
can be armed,
Yes.
and can be unpredictable in their behaviors.
Yes.
And there is a need then to react quickly to what an officer sees. Is that correct?
Correct.
And what you train in an omnibus way is for them to be to have the tools they need to respond. Is that correct?
Correct.
To respond quickly,
Yes.
and then you leave them with a certain amount of discretion to make that decision depending on individual circumstances. Okay?
Absolutely.
Now, Officer Potter attended your classes that you've described. Is that correct?
She has.
She was an attentive student, right?
Yes.
She fully participated in all your scenarios. Is that correct?
Yes.
Okay. She didn't miss any of your classes or skip out.
If she missed them, she wouldn't have been on a roster,
But-
and then she would have had to make up that training.
Yeah, but if she's on your roster, she attended.
Correct.
Okay. And you knew that she was an FTO, is that correct?
I did.
And an FTO is a field training officer,
Yes.
and the field training officer on the street has a number of duties, is that correct?
Yes.
And there are a lot of things. There are a lot more things going on for a field training officer than just an officer on the street ordinarily. Is that correct?
Yes.
I mean, you have this is obvious to you, but you have supervisory capacities, right?
As a field training officer, you certainly do.
You have the evaluation capacities, right?
Yes.
And all of a sudden, you have two officers on the street thinking perhaps different things.
Correct.
Now, this Taser 7 that we've talked about, this was a new product, was it not?
For our department, yes.
And it just came out. You just bought some, right?
Yeah, we had just purchased them in the beginning of 2020.
Okay. And,
I'm sorry, 2021.
2021. You have no evidence that she ever used the Taser in the field, do you? You'd certainly know about it if she did.
I would know about it if she did, yes.
And you have no evidence that she did, right?
No.
Okay. But these new Tasers were in working order.
They were?
And I assume they're like every other new product. There are certain advancements or improvements compared to the old product, right?
That's the reason we would have gone to a new product.
And would it be fair to say that the battery capacity of the new Taser would be at least similar or better than the older Taser in play? Is that correct?
Better.
And the battery capacity lasts a while, does it not?
Yes.
I mean, it doesn't need to be charged every day,
It does not have to be, no.
especially if it's not used. Is that correct?
Correct.
And the last training that she received on the Taser 7 was on March 2nd,
I believe so. That was the date that she was there.
but she didn't get her gun until later in March, like the 26th, according to the records.
Do you mean a taser?
Yeah, the Taser, I'm sorry.
Yeah. It wasn't until a little bit later that month that we were actually able to deploy the tasers to the field.
She was the first one to get it, right?
One of a group, I believe.
And by contrast to the new Taser, the firearm that she had was a semi-automatic,
Correct?
a Glock.
Yes.
And that Glock has been around the police world in which you have it for decades now. Is that correct?
The product has been around for a really long time. That specific one, we had changed out to a new fleet of handguns in 2012, I think it was.
Okay. So she'd had that gun for almost 10 years,
Around that,
and
yeah.
it was the same kind of gun.
Similar
I
in
mean, it's
function.
not an
yes.
electronic gun. It's just a handgun. I don't say just a handgun. It's a handgun that's built similarly for the last decades, 20, 30 years ago.
Yes.
I mean, they used this kind of mechanism in World War II.
Yes.
And that was the Glock, or a similar gun to the Glock that she had been trained on repeatedly by you and by the department. Is that correct?
Yes.
It's the Glock that she had on this person that she went to the firing range on a regular basis. Is that correct?
Yes.
And did all the other trainings that you had with her. Is that correct?
Yes.
Now, the training that you have in tasers is such that you try to get close to what it's like in real life to use them and what the officers face. Is that correct?
As close as we can in the training session, yes.
But you never can quite reach that level, of course, right?
Never will be able to.
Okay. So you do the best you can do.
Correct.
Okay. I mean, you can't, for example, replicate a car taking off.
That would not be safe in a training environment.
You can't replicate an officer who is inside a car that might take off. Is that correct?
Not practically. In talking about it, we do, but
Yeah,
not.
but you'd never put someone in harm's way during training, obviously, right?
No.
Okay. And you know from your training, you tell the officers that every response by the individual officer will be unique, right?
Can you say that again?
Every officer will respond in a unique way to the training. Is that right?
Correct.
I mean, everyone has different blood pressures that go up, right?
Yes.
Everyone has different reactions to adrenaline.
Correct.
And officers see different things at different times during your training exercises, right?
Absolutely.
And even during all your training, you recognize that certain officers take different routes and exercise discretion differently. Is that right?
Correct.
And there may not be any one right answer.
Correct.
In fact, some of your training exercises are designed so there may not be a right answer.
Yes.
And lately with COVID, it's been difficult to have in-person trainings. I think you mentioned that yesterday.
It has been extremely difficult.
I mean, you used to use volunteers, as I understand it, strangers, so that the officers wouldn't know who they are, right?
Not strangers, but civilians in our department.
Okay. But that's not really possible nowadays.
We're getting a little more back to normal, but still not where we were 2 years ago.
But even earlier this year, it wasn't advisable.
No.
Okay. And that's why you had a training session on March 2nd involving you
Correct.
as a subject because it was the safest thing to do in light of COVID and the restrictions you were under. Is that correct?
Yes.
And you talked about scenario training yesterday.
Yes.
Scenario training would be where the officers are required to react to a certain situation where there's a person. Isn't that right?
Yes.
And you yourself on March 2nd created 2 scenarios where the officers would react. Is that right?
I did.
And it's the only training on a scenario that was given for the TASER 7. Am I right about that?
Can you rephrase?
Was March 2nd the only training given on the TASER 7?
Yes.
Okay. So you were the person who was acting in such a way that would provoke a police officer to decide to do something, right?
During the scenarios, yes.
And I think one of them was you came out of a closet or some doorway with a club in your hand. Am I right about that?
It was a bat.
It was a bat. And then you motioned the bat towards the officer and they had to decide what to do, right?
Correct.
Whether it be a taser or a gun, right?
Or any of their other tools that they had on their person.
Okay. And some of the officers shot you with a taser.
Some did.
Some shot you with a gun.
None shot me with a gun.
Okay. But in any event, the exercise was the best you could do, but the officers knew who you were,
They did.
and a lot of them are friends of yours.
Yes.
It's a tight-knit department,
Very.
and they knew that you weren't going to try to kill them.
Yeah.
They knew you weren't going to take flight.
Yes.
They knew you weren't high.
Correct.
They knew you didn't have a bench warrant.
Correct.
They knew you didn't have a gun.
A real gun, yes.
And they knew you didn't have an access to the gun around your person.
Correct.
And they knew that you weren't going to use a gun. Real gun.
Yes. Okay.
And they knew you weren't going to hurt them.
Correct.
Now, one of the things you do in training is talk about the policies of your department. Is that right?
Some of the policies, not all.
And yesterday we talked about the TASER policy, which is number 304.
Yes.
Okay. And I don't think I need to show it on the screen, but I do want to ask you some questions about it. That was Exhibit 334.
Okay.
Okay. And you've almost memorized this, haven't you, over the years?
Not verbatim, but I have a general idea how to put it in practice.
I mean, you've talked about this hundreds of times.
Yes.
And the early part of the policy is at 304.3, and it says the officer shall, the verb is shall, only use a TASER device that has been issued by the department, right?
Correct.
Okay. So you want to control what they use. They can't buy their own.
Correct.
And then also in that section it says the officer shall carry the TASER device on the reaction side. Is that right?
Correct.
And then in the middle, we've had a discussion here. It said members, quote, members carrying the TASER should perform a spark test on the unit prior to every shift. Is that correct?
Correct.
Okay. A should is the verb, and it differs from shall as a verb, right?
Yes.
Okay. And should is an aspirational verb. In other words, you encourage the officers to test and do a spark test before every shift, right?
Correct.
It doesn't always happen.
It does not.
And there are a lot of things going on in In fact, we have testimony that on 4 of 6 shifts it didn't happen with Officer Potter, right?
Correct.
And it hasn't happened with other officers too.
Correct.
And you're not, she was never reprimanded, or you never talked to her, for example, about, well, do a spark test. You missed a couple, I assume.
The objection is overruled. You may answer.
Can you repeat the question?
Okay. Also in this section 304, you talk about verbal warnings that must be given to the subject who may be tased. Is that correct?
Yes.
And the idea here in the policy is the individual should be warned, if possible, that a taser may be employed. Is that correct?
Correct.
In fact, it says a verbal warning of the intended use should precede its application, right?
Correct.
It doesn't say shall, it doesn't say required, right?
Correct.
And the reason you do a warning, you teach everyone, including former Officer Potter, is that you want to provide the individual with notice that something may be happening, right?
Yes.
I mean, you've been tased, it's painful.
It is.
You don't want to repeat it.
Correct.
It's designed to disable you.
Yes.
And even a big guy like you were disabled temporarily.
Yes.
So the reason you give a warning is to provide the individual with an opportunity to comply, right?
Correct.
I mean, the hope is that they will.
Always is the hope.
And then you want to provide a warning that it may indeed be deployed. Is that correct?
Yes.
So a typical warning that you teach is, "I'll tase you. I'll tase you."
Correct.
And it's said in a vocal, loud way, so the subject will understand what you're talking about, right?
In plain English, yes.
So it's consistent when someone's going to use a taser to say, "I'll tase you. I'll tase you."
Yes.
That's what the department wants someone to do.
It's one of the many things that we teach them to say.
And then there's a section on application of the taser, 304.5.1, that permits the use of the taser, or suggests the taser can be used, right?
Yes.
Under certain circumstances.
Yes.
And one of the circumstances is if the subject is violent
Yes.
or is physically resisting.
Yes.
I mean, if someone is resisting a cuffing and attempts to get back into a car, for example, that person can be tased.
Yes.
Or you can also tase, according to your policy, not you, but an officer that you train, if the subject has demonstrated by words or action an intention to be violent. Correct?
Correct.
Or to physically resist. Right?
Yes.
Or if that person is a potential harm to others.
Yes.
So all those factors can be considered
Yes.
in employing the taser.
In a very short amount of time.
In fact, the decision I'm glad you mentioned that the decision to use a taser is really quick.
The decision to use any.
The objection? Well, I'll let the answer stand. You can finish what you were going to say.
Any use of force has to be made in a very short amount of time.
But what you don't want to use a taser if someone's physically running away from you necessarily.
Necessarily, but it's not an absolute no.
Okay. And you don't want to use a taser if a car is moving.
Correct, moving.
But if a car, on the other hand, is stationary.
We've used it many times on people inside vehicles that are stationary.
And one of the things you teach is whether individual has quote-unquote control over the motor vehicle, right?
Yes.
And the rule that you teach, I think, and you tell me if I'm wrong, is that if the individual doesn't have control over the car, the taser would be appropriate.
It certainly could be depending on the circumstances.
And again, you rely on the officer's discretion to make that decision.
Yes.
Now, we also heard a lot of testimony about taser warnings. One of the warnings was in Exhibit 270. You recognize this kind of thing, don't you?
Yes.
Okay, you've seen this dozens of times.
Yes.
And this is a warning that's issued by the taser manufacturer, as I understand it.
Correct.
It's made by Axon, is that right?
Yeah, that is the company that distributes the taser products.
And they warn about all sorts of things that can go wrong when you're using a taser.
Lots of things.
And this purpose of this warning that you showed us yesterday is to have the person undergoing training release the taser company from liability in case something goes wrong during training using the taser.
That specific document?
Not this specific one, but in general, that's why they sign these releases, right?
That's why they sign the training form that I then sign later certifying that they can carry a taser.
So the training form not only recognizes their completion of treatment, but releases the taser company from liability during the training.
Correct.
And one of the warnings of this document, 270, that we saw is that there can be a confusion between a taser and a handgun.
Yes.
And there is a recognition thus by the company that makes these things that there can indeed be a confusion between the two.
Yes.
Otherwise, why warn you, right?
Right.
And there have been confusions between tasers and guns
Several.
across the country.
Yes.
And in fact, the taser is shaped, at least on a handle basis, like a gun, right?
It is?
It has a trigger, right?
Yes.
The handle may be smaller, but it's
Yes.
still a gun handle,
To fit into a hand, correct.
especially a smaller hand.
Any hand.
And one of the reasons the taser manufacturer releases or wants all these releases is that they know, and you know from training, that mistakes can happen.
Correct.
Mistakes can happen during training when someone is trying to use a taser.
Yes.
And mistakes can happen when someone confuses a taser with a gun.
Correct.
And it can be an innocent mistake.
Certainly can be.
The objection is sustained. And the answer, the jury will disregard that asked question and answer.
And in every training exercise you do, there are these release and warning requirements. This is Exhibit 369 from yesterday. Do you see this? You recognize this, don't you?
I recognize it, yes.
I mean, this is by it's a training and warning requirement that is insisted upon by Taser, the Axum Enterprises that makes it, right?
Correct.
In fact, you are constrained during training to do exactly what Taser wants you to do.
Exactly what they want us to do.
And that's a precondition of even owning or using the Taser itself, right?
I'm not sure if it's a requirement of owning it, but it is a requirement of us going through instructor training.
Okay, got it. Now, you also teach in use of tasers and use of force of the various statutes from Minnesota, do you not?
I do.
And I've looked at your training materials, and one of the statutes referenced is Minnesota Statute 609.06. Is that correct?
Yes.
Okay, that's the statute that permits reasonable force to be used in making towards an individual under certain circumstances. Isn't that right?
Of an officer and other people in the state of Minnesota, yes.
But it's designed to give some clarity to what an officer can do vis-a-vis a reasonable force.
Correct.
And it gives criteria or examples of what can be used in reasonable force by the officer, right?
Yes.
And you teach this,
Yes.
almost with your eyes closed,
Depending on the day.
after all these years.
Yeah.
And the statute says that reasonable force may be used towards a person without the other's consent when the following circumstances exist or the actor reasonably believes them to exist. And the circumstances include, for a police officer at least, in effectuating a lawful arrest. Correct?
Yes.
In the execution of legal process.
Yes.
In the enforcement of an order for the court. Is that correct?
Correct.
Such as a bench warrant.
Yes.
Or in executing any other duty imposed by the public officer by law. Is that correct?
Correct.
So you can use reasonable force to make an arrest if
Yes.
the circumstances permit, correct?
Yes.
Objection has to be answered.
The objection is overruled. I'll let the answer stand.
And you can use reasonable force to enforce an order of the court.
Yes.
A bench warrant is an order of the court, right?
Yes.
Directing you as a police officer to make an arrest of the individual.
Correct.
I mean, a judge has directed you to do that.
Yes.
And as a part of your obligations as a police officer, you're to honor that bench warrant.
Yes.
You just can't close your eyes to it.
No.
And then there are criteria according to your outlines, which I've read too, on the factors to be considered when you judge what a reasonable force should be used. And one of the factors is the threat, the possible threat of the arrestee, right?
Correct.
How fast it occurs.
Yes.
Whether the arrestee is high or impaired.
Yes.
The seriousness of the offense.
Yes.
By the way, is fleeing a police officer a felony in Minnesota
It depends how they're fleeing.
in a car?
That is a felony.
Is it in Minnesota a dangerous offense in your view?
Objection, Your Honor, foundation.
The objection is sustained.
Well, does fleeing a police officer at a high rate of speed suggest to you a certain amount of dangerousness?
Objection, Your Honor, relevance and foundation.
Well, the objection is overruled. You may answer that.
Can you repeat?
Well, does fleeing an officer in a car at a high rate of speed suggest to you a certain amount of dangerousness?
Yes.
And why is that?
It puts the person driving that car, the officer, and the general public at risk in their attempts to evade the officer.
And the public's at risk because, as you've seen in your career, the individual fleeing a police officer can crash.
Yes.
Often does.
Frequently.
Kill somebody.
Can.
And that's why it's so dangerous.
Yes.
And it's important in making an arrest to prevent that sort of thing from happening.
Yes.
That's your obligation as a police officer, right?
Correct.
Now, you also teach another statute on the use of deadly force. I know you're here for taser, but I want to ask you a couple questions about it, all right?
Sure.
And that's statute 609.066, is that right?
Correct.
And that permits the officer to use deadly force under certain circumstances. Okay?
Correct.
And you teach this.
We do.
And the circumstances involve an apparent risk of if there's an apparent risk of great bodily harm or death
Yes.
to the officer herself or
Yes.
himself, right?
Yes.
To the other officers on the scene
Correct.
or the community nearby.
Correct.
And if there is an apparent threat of death or great bodily harm, deadly force can be used to prevent an escape or facilitate the capture.
Can you repeat?
If there is an apparent risk of great bodily harm, can deadly force under this statute be used to effectuate an arrest or prevent an escape?
Yes.
And when you evaluate the use of a deadly force, you teach that it's a decision that's made right there and then.
Correct.
It's not the subject of hindsight.
Correct.
It's not whether someone would have done something differently after the fact.
Correct.
It's not the subject of a 2020 vision.
Correct.
And it's a decision that's made under rapidly evolving circumstance, right?
Yes.
That's right out of Graham versus Connor, which you teach too.
Correct.
And finally, the decision is made at the very moment the force is used. Is that correct?
Yes.
And it's what was known to the officer at that moment.
Correct.
You also teach that the stressors involved in critical incidents, as you mentioned, vary from officer to officer, right?
Could you repeat that?
The stressors vary from officer to officer.
Correct.
One officer may freeze, for example.
Hopefully not.
You train not to, right?
Correct.
You train action.
Yes.
You train make a decision
Yes.
at the spur of the moment.
Yes.
Even if it's the wrong one, you make a decision.
Yes.
Because if you wait, that can be deathly too.
For multiple people.
Now, you have not, in your capacity as a witness, seen any of the videos in this case, I think, right?
Only small snippets months ago.
All right. So, in fact, you haven't wanted to because you knew you were going to testify as a trainer.
Correct.
Okay. So you didn't want that to be in your brain, so to speak.
Correct.
And you knew it, once you saw it, it wouldn't leave you.
Yes.
Because you knew everybody here. You knew everybody in the video.
Very well.
Now, but you do teach officers that, where there's a warrant for a gun charge, they should make the arrest. Am I correct? If there's a bench warrant.
Can you say that again?
Where the suspect has a bench warrant for a gun charge, they should make an arrest.
Yes.
They can't let him go.
No.
You also teach that when a gun is involved on a bench warrant, that the officer should be vigilant about another gun being in the car at issue,
Absolutely.
or a gun being on the person. Is that correct?
Yes.
And you train this over and over again, right?
Yes.
Because stopping someone in a car is one of the most dangerous things you can do.
Yes.
And police officers who aren't vigilant and are not aware of the dangers can be shot.
Yes.
Have been
Yes.
in Minnesota.
Yes.
Just because a gun isn't found later in the car at issue doesn't mean the officer's interest in or belief a gun is there is invalid, though.
Objection or relevance?
The objection is overruled. You may answer.
You want me to repeat that?
Please do.
Just because a gun isn't found doesn't mean to you that the officer's interest or belief a gun may be in the car is invalid.
I think we're having a technical problem. Hang on there, folks.
It's unsafe to drive without insurance,
Yes.
because that's a requirement too, right?
Of the state, yes.
Another community interest is to validate court orders.
Yes.
The guy's not supposed to be on the street, he's got to get off the street.
If that's what the court said, yes.
Is the use of a taser a form of de-escalation, in your view?
Yes.
Meaning that instead of, it can de-escalate the situation by incapacitating the defendant or the suspect, right?
Or other ways, yes.
So you're taught to use the taser to de-escalate a situation, fair?
Yes.
You're also taught, you also teach that you can't always predict the arrestee's behavior.
Correct.
Now I want you to, I know you haven't seen the video, but I want to give you a hypothetical and ask whether the use of the taser would have been appropriate, okay?
Okay.
Let's suppose that an individual's driving a car. He is stopped for legitimate reason. Let us further suppose that when asked for a license, the individual doesn't have a license. He doesn't have any identification. There's no insurance current on the car. Let's further assume that the individual has a bench warrant for a gun charge. And let's assume further that there's an order for protection against him, and then there's a female in the car, and a female is listed on the order for protection. Okay? And let's assume further that when the individual police officer in my scenario tells the individual to get out of the car and tells him further that he's under arrest, and the individual resists arrest. And the individual is told by another officer on the scene, I'll tase you, I'll tase you. The individual climbs back in the car that's stationary, but attempts to engage the car. It is not moving. Under those circumstances that I've outlined for you, would it be reasonable for an officer to fire a taser to stop this individual?
Your Honor, I'm going to object on false or speculation, foundation.
The objection is overruled, and you may answer.
If that
You also teach, I've got just a couple more questions for you. I appreciate your answers. You also teach that mistakes can happen in police work.
Objection, Your Honor.
The objection is overruled. You may answer.
mistakes can happen in every part of our world.
Accidents can happen.
Yes.
They're no matter how hard you train, no matter how hours you put into it, policing and living is a human endeavor.
There are too many variables to have planned out in advance to be able to eliminate that forever.
And we're all engaging in the endeavor of living imperfectly.
Correct.
But when someone, like a police officer, yells out, taser, 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 and shouts at a suspect, does that indicate to you that a taser is about to be used?
Yes.
You've known Officer Potter for 15 years.
If not longer.
And you're familiar with her character and reputation in the community.
Yes.
I mean, you've watched her, worked with her. It's a close-knit community, right?
Yes.
Does she have a reputation in your community for being peaceful?
Objection, Your Honor.
The objection is overruled.
Can you repeat?
Pardon me?
Can you repeat?
Does she have a reputation in your community for being peaceful or having the trait of being peaceful?
Yes.
peacefulness. Does she have a reputation in your community for having the character trait of being law-abiding?
Yes.
Yes, she does. Do you have a moment?
Yes. All right, redirect, Mr. Frank.
Thank you, Your Honor. Thank you, Sergeant Peterson, for coming back again this morning. Um, you were
It's not part of the curriculum, but when officers do things in training that may not be what they wanted, we retrain that. So I would classify that as being an accident. It's not something that they wanted to have happen.
and then you would correct that, you would address that?
Yep. During our debrief, we would talk about what they didn't like about it, and then give them an opportunity to put a positive training scenario conclusion into their brain.
During this training on March 2nd of this year, you did this scenario and with the bat, correct?
Correct.
And you said nobody shot you with a gun, right?
Not for that specific part of the training.
And did anybody draw their gun, saying that they actually meant to draw their taser?
I do not recall.
And I think, well, in that scenario, as with all scenarios, they know they're being assessed, correct?
Yes.
And they're being assessed on whether their behavior is in accordance with reasonable expectations of the department about how an officer should react in situations.
Based on state law and policy and court cases, yes.
You were asked about driving without a license and driving without insurance. You have any idea of how many times you've stopped people on duty in Minnesota that did not have a license?
Objection beyond the scope.
The objection is overruled. You may answer.
How many times I've stopped somebody without a license while working as a police officer?
Correct.
That's the question? Hundreds.
And how many times have you stopped people and found out they did not have insurance?
Hundreds.
Do you recall, how many times in those hundreds and hundreds of those stops they were driving unsafely?
I didn't hear the last word.
That the drivers that you stopped had been driving unsafely.
That'd be really hard for me to put a number on over a 16-year career.
I'm trying to figure out. Oh, sorry. So I'm trying to figure out, what it is about not having insurance that means they're an unsafe driver.
It would depend on the driver, I guess. I mean, there'd be specific circumstances for that stop, but generally, I have seen that people who don't have a license and insurance don't follow the rules of the road the way people who do have a license and have insurance do.
So when you're stopping somebody, you don't know if they have the fact of insurance alone doesn't make them unsafe.
No, and that's not something I know before the stop.
You were asked about de-escalation, correct?
Yes,
And de-escalation is in fact something you teach as part of the training of officers in Brooklyn Center.
it's something we teach and our profession has done for decades.
And in fact, it's mandated by post, isn't it?
Recently, yes.
And part of that A through F that we looked at the other day, part of the post mandates.
Yes,
And so using a taser, you indicated, is one way of de-escalating a situation, correct?
it can be.
And it can also, however, could it increase the risk to others in the area? The risk of harm, I should say.
That's a really general statement for me to be able to answer.
Well, you answered, that it can be used to de-escalate,
Yes,
and that's by incapacitating the person, correct?
yes,
And so that then brings down the activity, shall we say, of the subject,
okay,
right? Is that what you meant by incapacitating?
yes,
And by incapacitating that person, that could have foreseeable effects as well for others.
again, it could depending on those specific circumstances.
Yeah. So incapacitating a driver, you don't want to do if they're operating the vehicle.
If the vehicle is in motion, correct.
And a vehicle that can be put into motion at that moment, is that really any less, in your opinion, is it less of a risk?
It would very much depend on the circumstances.
And you are not familiar with the exact circumstances of this incident, correct?
I am not.
You have not done any interviews of witnesses
No,
and not gone out and viewed anything more than just the couple of snippets that you referenced.
not intentionally.
And by not intentionally, you mean
Those snippets.
you saw those just,
The news was on, and by the time I turned the channel, I had seen part of it.
okay. And you talked about, or you were asked about stopping the car. Stopping a car is a dangerous situation, correct?
Correct.
Not all stops are dangerous, but it is a dangerous situation for officers, right?
One of the higher dangers, yes.
And is that one reason why officers will often stop when another officer already has a vehicle stopped to provide backup?
Yes.
Does the presence of more than one officer help with ensuring the safety of the officer and others?
It should, yes.
And that's the whole point of backup, right?
Correct.
You were asked a couple times about well, let me back up to the situation involving the vehicle. When whether a vehicle is moving or stationary, an officer has to consider, when using force, the presence of other occupants in that vehicle, right?
Yes.
And you were asked this hypothetical, and what I want to ask you about is when assessing whether to pursue somebody that you have stopped and is trying to get away, is one factor for the officer to consider when using force whether that person has been identified and could probably be found later.
That is one of many factors.
You were asked about the term hindsight, correct?
Yes.
And that's in your training materials?
Over the years, yes.
And what does that mean to you?
It means that the incident will not be judged by anybody with information that was collected after that incident.
And so that determination of the reasonableness of the officer's force, if I understand what you're saying, is not based on things the officer didn't know at the time.
Correct.
You also talked about the language about 20/20 vision. What do you mean by that? What is your understanding of that term?
It's similar to that hindsight, that information not known at the time of the incident to the officers on scene cannot be used to determine the reasonableness of that force.
Do you know if those terms are actually in the statute about force, authorized use of force?
In statute?
Correct.
They're not in statute, but they're in case law.
And you accept the proposition that here in court the judge will give the jurors instructions on what the law is to apply here.
Yes.
You were asked several times about a warrant authorizing an officer to make an arrest, correct?
Correct.
And you were asked, that means they have to arrest them, correct? You recall being asked that?
Yes, depending on the warrant.
And does it, in fact, in all circumstances, require that officer to make a custodial arrest at that moment because of the warrant?
A custodial arrest where the person is placed into jail, not all warrants require that.
Okay, fair enough. In executing a warrant, making an arrest, as you were asked about earlier, officers still have to determine the amount of force that they will use to make that arrest.
Correct.
And a warrant still requires that an officer use reasonable force to make the arrest, correct?
Yes.
And if an officer determines that they cannot safely make that arrest, safety for themselves or others, that's a decision they can make, correct?
That being only one of many criteria.
Sure. So they have, while there is a court order, they have some discretion on how they make that arrest on that warrant.
Some. In determining whether an officer can use force on an occupant of a vehicle, you've drawn a distinction between the vehicle moving and not moving, correct? Correct.
Does the officer have to take into consideration the ability of a person to put that vehicle in motion?
I'm not sure I understand.
Okay. So if you have an occupant of a vehicle, stationary, but the occupant is in the driver's seat, the engine running, foot in the floorboards, does an officer have to decide, take into consideration at least, whether that person has the ability to then move that vehicle?
In fractions of a second, yes.
Why do you say that?
Because life happens really fast in force incidents.
So it would depend on the circumstances of that situation.
Correct.
But it is something to take into consideration.
Yes.
Because if the person, if an officer used force on that individual and they were able to put the vehicle in motion, would you have the same kind of concerns in that situation as your other scenario where the vehicle is already in motion?
It would depend on the type of force that was applied at that time.
Okay,
And then-
to the person driving the vehicle.
Correct.
Is it dangerous to incapacitate a person who's operating a vehicle when it's moving?
It can be in short durations.
And, okay. Incidentally, you were asked about confusions. You indicated there have been cases of confusions of a taser and a handgun.
Correct.
Do you know how many there have been?
I do not.
When you testified yesterday about proficiency, remember I asked you how you define that. And does proficiency include training to know the feel of a taser?
It's not something that we specifically discuss.
And in your training, your policy requires that officers perform draws of the taser so that they become proficient at doing so.
Yes.
And so that is done as part of the training?
Yes.
Have you ever drawn your handgun when you meant to draw your taser?
Not that I recall, no.
You testified during cross-examination that the use of force often has to be arrived at the decision in a short amount of time, correct?
Yes.
And the scenarios that you have been running with your officers for 8, 9, 10 years, that's an aspect of those scenario trainings as well, making them happen quickly.
Yes.
You're familiar with this, well, let me ask you this. The Taser 7, you were asked about the transition course. Did the previous model of the Taser 7, or the Taser that you used was X26P, correct?
Correct.
And was that also yellow?
Ours were yes.
And did it have a safety switch?
Yes.
Did it have the CID display in the back of it?
It did?
Did it have at least one laser and a flashlight?
Yes.
Was there anything different about the basic function of the Taser 7 from the XP26 in terms of drawing it and deploying it?
The basic function, no.
The spark test that was in policy existed, or that requirement was in policy as well with regard to the X26P, the previous model.
Yes.
And Mr. Eng told you what should means, but is it expected that officers will follow that part of the policy to perform a spark function test?
As much as possible, yes.
Well, what would make it impossible to do?
If as soon as we got into roll call, a shooting came out and we had to run out to go render aid.
And so it would be that kind of circumstance that would excuse an officer from doing the spark test?
The immediate call for service, yes.
What is the purpose of the spark function test?
It depends on the model.
Well, for purposes of the Taser 7, what is the purpose?
To ensure that there are no major faults with it and that it's going to operate when the officer needs to use it on the street.
So to assure that somebody who's working with you and is going to deploy their Taser for a good reason, you want to make sure that that happens, correct?
Yes.
You want to make sure their Taser is working,
Correct?
and if you're going to deploy your Taser at that moment when you have to, you want to make sure it's going to work.
Yes.
And so, would a good officer do that every shift?
Yes.
Have you done scenario-based training where the scenarios involve the stop of a motor vehicle?
Yes.
In fact, I think some of them refer to high-risk stops, correct?
That's a different type of vehicular stop, yes.
Okay, why? What makes it that?
Circumstances of that stop would have us not approach the vehicle. We'd wait until there's additional squads there, more than just two, and we would call the people out of the vehicle back towards us rather than us going up towards the vehicle.
So a much different structured or approach to the vehicle.
Correct.
But you have done regular vehicle stops in your scenario training?
Yes.
And in some of those have the role players that are the driver of the vehicle attempted to flee.
I don't recall.
Is that a possibility that that was done in scenarios?
Certainly is a possibility.
Is something officers would need to be, well, is that something officers would need to be prepared to handle out on the road?
Yeah. Yes.
And when you're doing those scenarios, do officers have on them gun, taser, baton, every tool that they can use when they're out in the street?
Inert training devices, as many as we can and that we're allowed to afford, that's what we employ during our training sessions.
When you are training on firearms and qualification for firearms, do you have to train, or do you train that officers must consider backdrop?
Yes.
And what does that mean?
That means that you are paying attention to the things that would be beyond your target in case a round did not strike your intended target, so that we would not inflict collateral damage.
And is that something officers have to take into consideration when using their firearm?
Yes.
Do they have to take that into consideration when using a taser?
Yes.
If I could just have a moment, Your Honor.
Yes.
So we're here on day 10. This is the redirect by Matthew Frank from the State
All right,
Prosecutor's
that's all I have.
Office.
Thank you.
Brooklyn Center Police Department Sergeant Mike Peterson.
Lee Cross, Mr. Ames, you may proceed.
couple more questions. You were asked whether a good officer would do a spark test.
I was asked that.
Well, a good officer might miss a spark test too.
They certainly
You
could.
can be a good officer and miss this occasionally.
Correct.
It's not the criteria you would use to judge a good officer.
Not in and of itself, no.
And the question of insurance, I mean, well, you'd look at the bulk of a career, for example, wouldn't you?
Can you say that
To
again?
judge whether an officer's good or not, you'd look at the bulk of a career too, wouldn't you?
Yes.
The body of her work, right?
Yes.
With the law, would you explain that?
I'm going to object, Your Honor, speculation.
The objection is overruled. You may answer if you can.
Do you remember the question?
Can you repeat it?
Sure. Well, you were asked on direct about insurance, and you indicated that when an individual has insurance, there is more of a proclivity to have problems, so to speak. I'm paraphrasing your answer.
When they do not have insurance,
Yeah.
they're more unsafe on the roads.
Yeah. Why'd you say that?
One of the primary duties of a police officer is to ensure traffic safety, to prevent crashes, to prevent people from driving under the influence. In my career, I have stopped people that have been not safe in their driving to meet those goals, and during those investigations, many times I have led to those people not having insurance.
And the lack of insurance harms the community.
Yes,
Because if there's a crash, there's no recovery by the automobile that doesn't have insurance,
correct,
which is the function of insurance to begin with.
correct.
And in fact, when you apply for a license on a car, you have to indicate the insurance company that covers the car, right?
I'm not aware what the requirements are to get a driver's license.
Now, when you apply for tabs, for example, do you have to say that you're insured?
Currently, the state has put that requirement in, yes.
And that's to ensure public safety, right?
I would believe so.
Now, you were asked some questions about cars and if a car is about to drive away. What the criteria you use is a control of the car. A control is the operative word you use in your training. Is that right?
Yes,
And you draw a distinction between a stationary car and one car that's in movement. Is that right?
correct.
Because that's all an officer can see.
Yes,
And you've had instances in your career where you attempt to make sure that the individual doesn't drive away from you. Is that right?
in my career,
Yeah.
yes,
So that the individual is prevented from taking control over the car.
yes,
The issue of a warrant, you were asked about speeding tickets and arresting people on speeding tickets. Do you draw a distinction between an arrest warrant for a gun charge and a speeding ticket?
yes,
And when you make an arrest on a warrant, the first thing you do is cuff. Is that correct?
when I make an arrest,
Yeah.
after telling them they're under arrest, yes, that would be to cuff them.
And then once you cuff them, you put them in your car.
Correct,
And then you figure out what you're going to do.
correct.
Now, in the scenario that I gave you on the use of tasers, one more fact that I want you to consider, one more hypothetical fact. Suppose further that a police officer is inside the car and the driver is attempting to leave, and the officer is, the door to the passenger side is open, and the officer is seen inside the car. Would a taser be appropriate to be used to stop the individual from leaving?
Where is the officer?
The passenger side, the passenger seat,
In an open door or a closed
open
door?
door.
And they're in the interior of the vehicle.
Yes.
And your question about that scenario for this is?
Should that individual be stopped?
Yes.
Redirect, Mr. Green.
Thank you, Your Honor. I will try to be brief. The additional facts added to the hypothetical, is it part of training that it is dangerous for officers to put themselves inside of a vehicle when a suspect is trying to flee?
It's something that we want to try and avoid, but it's not always avoidable.
And if an officer determines that they can do that and stop the fleeing by rendering the vehicle inoperable, shutting it off, putting it in park, that would be a decision for an officer to make. Could be one decision they could make.
Yes.
So just because, well, let me ask it this way. If an officer, there is a danger that an officer could get dragged by a fleeing person, correct?
It is a danger.
And officers are trained on that danger.
Yes.
And but the mere presence of the officer to some extent into the vehicle is a determination an officer has to, is a fact an officer has to consider when deciding whether that officer is in danger of being dragged.
In any rapidly unfolding incident, there are many factors that officers have to make, and they have to make those decisions in a very short amount of time.
And so the answer is that is a consideration for them.
Of many.
And the officers that you have trained for Brooklyn Center would know that it's dangerous to place themselves in a position where they would be in a vehicle that could be.
Objection foundation.
The objection is sustained.
Well, I asked, well, is it part of your training then that officers should not put them in a position like that in a vehicle?
We do not deal in absolutes because no incident in this world is ever forecasted. We give recommendations. We give officers as many hypotheticals as we can, but the world is constantly moving and evolving. It's something that we warn on, but it's that officer's determination at that time in that specific incident that is different than any other incident that they have probably been in to make that decision.
Fair enough. And so what you're saying is it all would depend on where that officer is, where their feet are, where they're located physically, if they're outside the door. It's going to depend on a lot of considerations.
It would depend on their actions, the actions of officers, and the actions of any suspects or any other people inside that vehicle.
But in terms of reasonable force by that officer, it's from that officer's perspective.
That specific officer's perspective, what their actions are.
That's all I have, Your Honor.
Okay, Mr. Ing.
During one of these critical incidences, all the officers are expected to help each other.
Can you,
During these instances where there's a decision that has to be made quickly, all the officers are there to help each other.
so you're not speaking about a specific incident, but the things that we do on a daily basis?
You're there to help your other officers.
Correct.
Anything further from the stage?
Oh, Your Honor, thank you.
All right. Thank you. You may step down. Okay, members of the jury, we're going to take our morning break. Okay?
Thanks for joining us. That was Mike Peterson, a sergeant at the Brooklyn Center Police Department. And, you know, I mean, frankly, he was able to give out a lot that you would think of as hearsay, you know, for as far as other witnesses were concerned about Kim Potter's reputation and stuff like that. So, I don't know. To me, it just seems striking that this witness seemed to be treated differently than a lot of the other witnesses, I think.
20 minutes, counsel.
All right, looks like we've been put over on break, so I think I can bring you footage from the April 12th, if you'll give me one moment, please. We have footage from April 12th out at the Brooklyn Center Police Department, so I'll bring that in. I believe we're on morning break now, but we've been hearing, you know, witnesses basically justify what Potter did, for one thing. So, you know, which is pretty striking, right? And we're going to probably hear more summation of that from the closing arguments, and the state is going to rest its case pretty soon. So, I don't know. We've been seeing quite a bit of that here. Thank you all for joining us, and I'll just mention quick, too, that Unicorn Riot is a 501c3 nonprofit media organization. We really count on your support. If you can go to unicornriot.ninja/donate. That makes a big difference. We try to release everything under Creative Commons, non-commercial share alike with attribution, so that other, you know, students and nonprofit media can reuse our work. So thank you all for joining us. I think we're going to be on break for a while, so we're going to put on some footage from April 12th. We really appreciate your support today. Thank you.
Hold up 1 second. I wasn't here for live yet. Oh, you ain't on live? Not yet. Oh, okay. And then you can be the first person I talk to. Oh, okay, good. What's your name? Jalen. Jalen? Yep. You can say it if you want to. You don't have to. Cool. I'm Nico. Good to meet you, man. Yeah. Hey, what's up, everybody? Welcome. This is Nico from Unicorn Riot. We're here live at Brooklyn Center Police Department, where you see the fence and 1,000+ people out here protesting for Daunte Wright.
Man, they're killing our people, man. It's over with, man. It's the revolution. We gonna turn this shit upside down, man. I'm tired of it. I'm tired of my black people getting killed, man. I'm so damn tired of it, man. We gotta change, man. We gotta change. The change come now. For all you listening right now, for all you that's watching this, know that the change is coming. Know that revolution is gonna come. Know that we have to do this, because these motherfuckers right here, they don't care about you. They don't give a goddamn fuck about you, man. They don't give a fuck, alright? We're here for you, alright? We're here for you. We on the front lines for you, alright? Y'all be safe out there, and I love y'all and everything, man. Just be safe, please, be safe, and don't be scared of these people, man, because we're here. We're here. This is our home. We made this country. We made this country. This country was built off the backs of the black people, the blood of black people, the blood of Asian people, the blood of Latino people, and all the minorities, man. We're here. This is our home. And the indigenous people, we're here. This is our home. We love you, and I hope y'all stay safe, man. Be good out there. Be good.
So you sort of catch the vibe from the first interview here. We see cats have full-on protective shields. It's a little rainy. Give me a second. So there's a curfew that has been initiated here for 7 p.m. We're over an hour after the curfew. This is the scene at the police station. A lot different than the vigil site, as you can see. We were just live at the vigil site. There's thousands among thousands of people in the street right now. The whole street off of 67th is filled. Going up a block or so. Very large crowd out here in Brooklyn Center in front of the police department, as they've activated numerous amounts of interagency cooperation forces, from state troopers, the National Guard, to Minnetonka, to Rogers, to Champlin, to Orono, to a bunch of different police forces, as well as possibly conservation officers from the DNR. You can see a new unit of riot patrol is running up in line right now. People have the lasers out and they're shooting. They're shining the laser onto the people on the roof. It doesn't look like the people on the roof have guns to be shooters. Excuse me, have guns to be crowd control munition shooters, but they are at the roof. And they're getting green lasers shown at them. One second. Okay, it's a little rainy today. There goes some shots of marker rounds. They've been shooting a lot already. We missed a lot. We have the leaf blower here. Those are pepper balls they're shooting. So the leaf blower is actually blowing off the pepper. Well, maybe it's pepper balls. I'm not sure. I cannot verify that. It seemed like some type of irritant, but also it smelled a little bit like deodorant spray. Maybe that's just what somebody next to me smells like. So you see this little flashlight war game going on with a person who is standing off to the right. We got people out here with the umbrellas. We got Cone Man. We got a flag being raised, Black Lives Matter flag.
Y'all gonna have lights. Y'all daughters gonna have lights.
This is a state trooper vehicle. That is an LRAD on the front, long range acoustic device.
Black Lives Matter. Black Lives Matter. Black Lives Matter. Black Lives Matter. Black Lives Matter.
shooting at the flag. Is that you? Love you. Sorry.
Black lives matter!
That was my fault, my fault.
Black lives matter! Black lives matter! Black lives matter! You can't take shit, fool! Black lives matter! Black lives matter! Black lives matter!
Looks like the police are moving one of their military vehicles up.
He's not doing anything! He's standing! He's standing! Y'all some old ass niggas! Hey, y'all touching me, beating your ass! Hey! He's not doing anything! Hey, y'all do anything, y'all be beating your ass! Stop doing that shit! Hey, you fucking the fuck! Hey, you racist as fuck! Hands up! You racist as fuck! Hands up! Hey, you racist! Hands up! Don't shoot! Don't shoot! Hey, you racist as fuck! You racist as fuck! You racist as fuck! Don't shoot! Don't shoot!
May I have your attention, please?
No, nigga! No, nigga! Fuck you!
May I have your attention, please? Captain Ryan on behalf of the Police Department. There is a curfew that went into effect at 7 p.m. You are in violation of the curfew and are required to disperse northbound on Humboldt Avenue toward 69th Street. Media is to assemble in front of 6700 Humboldt Avenue. If you continue to violate the curfew order, you are in violation of an unlawful assembly. Please abide by our direction. Disperse peaceably. Thank you for your cooperation and adherence to our directive.
Abide by the law! Follow the law! Canadian! Fuck you! We matter until we matter, bitch! Listen to us! Listen to us! Hey! Get rid of all that racist
Not really sure what they're shooting at. Very peculiar smell. I don't know what device they're shooting. It smells some kind of pepper or something, but it smells like deodorant, like weird deodorant smell, like deodorant spray. But just like the one you get at a commissary in a jail or something, like not the best quality, you know. Like not Family Dollar, but just like Dollar Tree. Anyways, we're here sort of right at the front. As you see, this is where the front line of the people are. And there's a gaggle of press over here as well. Whew. So we got the leaf blower. What's happening? Again, everybody's out here for Daunte Wright. And then Daunte Wright was killed yesterday. He was 20 years old. Let's see if we can get you a clear view in between. We're gonna have to move back a little bit just to try to get you a better view. I think we might be impeded from seeing the police officers shoot today. The officers are putting gas masks on, so they're getting ready to shoot, to fire tear gas. You see National Guard in the distance back by the police station.
And we pay for all that shit! We pay for all
Yeah, I saw that. You saved my lungs. Solidarity.
Don't shoot! Don't shoot! Don't shoot! Fuck 12! Fuck 12! Fuck 12!
Oh, bro, I got a Red Bull.
There's really a house right here. Shooting a lot of those munitions. Ended up going right next to that house. We saw yesterday a bunch of the apartment buildings be awash with smoke. Here we got the umbrella brigade.
Alright, we are back. Had a little slip with my interface there, but we're back live now. Thank you all for joining us. We're on day 10 of the Kim Potter trial. We are expecting the prosecution to close out its case. As one of the commenters said, the last witness was someone that knew Potter for a very long time, and that definitely came across in the testimony. So I'll just add that quick. Looks like the jury's coming back in. It's about 10:50. Thank you all for tuning in. Again, if you want to head to our website, unicornriot.ninja, share our work out there, please check it out.
Okay, please be seated. The state may call its next witness.
Thank you, Your Honor. The state would call Professor Seth Stoughton.
Professor, good morning. Will you please come forward and then stand behind the witness chair, which is right next to me. Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
I do.
Please have a seat. And would you please remove your mask? And state your full name and spell it.
My name is Seth Wayne Stoughton, SETHWAYNE STOUGHTON.
Okay, thank you. A couple of things to keep in mind when you're testifying. The court reporter that's sitting right in front of you is taking down everything that's being said. Therefore, you have to answer with a yes or a no instead of shaking your head, and don't say uh-huh or uh-uh.
I understand.
All right. Only one person can talk at a time. Wait until the question's finished before you answer. If an objection is made, you've got to stop talking immediately and don't answer the question unless I tell you to. If you don't understand the question, please let the questioning lawyer know. Okay?
Thank you.
Counsel?
Thank you, Your Honor. Professor Stoughton, can you tell the jurors how you are currently employed?
I am an associate professor at the University of South Carolina School of Law and an affiliate with the Department of Criminology and Criminal Justice.
And that department, is that also at the University of South Carolina?
It is, yes.
So the law school plus like an undergrad department?
Yes, my primary appointment is at the law school. I have an affiliate or courtesy appointment with the Department of Criminology and Criminal Justice because of the nature of my work.
And how long have you been serving in those roles?
The affiliate appointment is relatively new, the last year or so, I would say. I've been a law professor at the University of South Carolina since 2014, summer of 2014.
And so do you teach classes at the law school?
I do, yes.
Do you teach classes at the undergraduate part of it as well?
I have taught a course at the university's Honors College, but it's not part of my normal teaching rotation.
So what classes do you teach at the law school?
I teach criminal law, criminal procedure, police law and policy class, a regulation of vice seminar. I have taught a class called Advanced Topics in Criminal Law, but only once, and I don't think I'll go back to it.
Do you also conduct research in that position?
I do, yes.
And what kind of research do you do?
I study policing, police culture, police regulation, policies, behaviors, essentially the rules and regulations, both formal and informal, that we use to get officers to do what we want them to do and to not do what we don't want them to do.
I'm going to back up a little bit and go into your educational background.
Sure.
And did you obtain an undergraduate degree?
I did, yes.
And where was that at?
Florida State University in Tallahassee.
Do you recall when you completed that degree?
I do. I started that degree in 1998, and because I'm a little slower than the average bear, I finished it in 2008.
And so most people don't spend 10 years completing their undergraduate degree?
It's a long time to get a 4-year degree in.
Was there something in the middle that interrupted or slowed down your progress?
Yes, in the first semester of my junior year, I went to the police academy and served as an officer, later switched jobs to become an investigator for a state agency. And the regular working hours as a state investigator allowed me to finish that 4-year degree.
So did you work as a police officer?
I did, yes.
And where did you work? What department?
The Tallahassee Police Department.
So that's Tallahassee, Florida?
Yes.
Is that where Florida State is?
It is.
And so when did you start working there?
I started there. I began the employment process in late 2000 and was employed there in March 2001.
So can you describe for the jurors what you went through training and education-wise to become a police officer?
Sure. I attended the Pat Thomas Law Enforcement Academy, which is our pre-service basic academy training. That was 5.5 or 6 months. When we finished, the academy that I attended was not agency specific. There were officers from a number of different agencies, including my own, who went there. So when we finished the academy training, my cohort and I had 4 to 6 weeks of additional classroom training at my particular agency, then a 3.5 or 4 month field training program before I was what they called solo and on my own as an officer in, that would be November of 2001.
And what were you assigned, what duties were you assigned when you started for the Tallahassee Police Department?
I was with the Uniform Patrol Division. It's our uniformed beat cops.
So what did you do as a patrol officer?
Over the 5 years I was with the agency, I worked in 2 of our 3 districts. We broke the city into 3 different districts, Alpha, Bravo, and Charlie. I worked in primarily in our Charlie district and our Bravo district. The primary jobs of a patrol officer are responding to calls for service, self-initiating activity like initiating traffic stops, conducting field investigations, making arrests, writing up information where you can't complete an investigation so that an investigator can pick it up and conduct additional investigation. I also had some additional duties not specific to my patrol function. I trained officers on report writing. I spent 2 years on our special response team, served on some committees doing policy writing for new technologies, among other things that the agency was adopting.
Did you have any other special assignments during those 5 years?
I taught for the city community self-defense classes, child molestation and abduction prevention classes. There would have been a bunch of things that came up on sort of an ad hoc basis, but in terms of repeat assignments, it was basically those around my core patrol officer function.
Were you licensed as a peace officer during that time?
Yes.
And did you receive training as a police officer?
Yes, both pre-service, that is before I was in a real uniform and in a car, field training, and then as an officer, annual in-service training.
And was that required to keep your license in Florida?
Yes, there were a certain number of hours that you had to complete every 4 years to keep your certification, and then by policy, my agency had additional training that it required us to go through annually.
And I think how long did you work there then as a police officer?
I left full-time at the end of October 2005. I stayed on as a reservist, which is a part-time officer, for about another 6 months until mid-2006.
During that time that you were working as a police officer, did you have occasions where you had to use force on individuals?
Yes.
Do you have incidents where you had to arrest somebody and take them into custody?
Yes, quite a few.
Did you have occasions when you had to handcuff individuals?
Sure. Yes.
And did you have to write reports?
Lots of reports. Yes.
Were those reports reviewed by others in your department?
Yes. Either a sergeant or acting sergeant, and then for some reports, our lieutenant or watch commander would review reports and approve them.
So you told the jurors that at one point you left that job. Where did you go?
I left the city police department for a position as an investigator with Florida Department of Education's Office of Inspector General, sort of like the internal affairs for the Department of Education.
And what did you do for that agency?
I was an investigator assigned to a mix of criminal and administrative investigations. The administrative investigations would be violation of department policy, anything from sexual harassment to, there were a ton. Someone who was running a real estate business out of their state office, for example. The criminal investigations, we had some that were in-house, involving criminal investigations of department employees, someone who had stolen a check, for example, as well as investigating criminal violations of Florida's private school tuition voucher program, which was associated or run through the Department of Education rather than local school districts.
Do you recall how long you had that job?
I was there from November of 2005 until June or July of 2008.
So while you were working there, did you then resume your education?
I did, yes.
Why is that?
Because I thought it was sort of sad that I was going on 7, 8, 9 years of not finishing a 4-year degree. Finishing my education was something that was important to me, something that was important to my parents, something that was important to my career trajectory. So definitely something that I'd always intended on finishing. I just didn't have the luxury of it doing shift work with the department.
And so you told, I think, the jurors earlier, you completed that degree in 2008, is that right?
Yes.
And what was that degree?
It was a bachelor's degree in English with a focus on literature.
And so then what did you do after obtaining that degree?
I matriculated, which is a fancy academic term of I went to law school.
And where did you go to law school at?
The University of Virginia School of Law.
And did you graduate from law school?
I did, on time even.
And how many, or when did you graduate from law school then?
2011.
And so did you go to work in the legal field then after graduating?
I clerked for a year, which is working for a judge, and then had the opportunity to pursue an academic fellowship, which I did prior to taking my tenure track position at the University of South Carolina.
And what is an academic fellowship? What kind of stuff do you do?
In the legal field, you can think of an academic fellowship as a little bit like what a postdoc would be in other fields. It gives an aspiring academic time to research, to write, to develop the body of written work that you need to get an entry-level tenure track job.
How did you get interested in doing that?
When I was in law school, I initially had no intention of staying in the criminal law field or doing anything with policing, but taking criminal law, taking a criminal investigations class, which is now the class I teach under the title Criminal Procedure, really got me interested in studying the rules that I had used as an officer from an academic and particularly a legal academic perspective.
And so what did you focus your research on during that fellowship?
On policing.
And after that fellowship, what did you do in your career?
In the second year of the fellowship, I went on the academic entry-level hiring market, got my tenure track job at the University of South Carolina, and ultimately accepted that and have been there ever since.
Now, have you authored any scholarly publications?
Yes, quite a few.
Can you generally describe for the jurors what they are?
I would love to. Yeah, I've written a number of academic articles on policing.
Yeah, we're losing our
The
audio.
effective police culture, on the regulation of officer behavior, some aspects of history of policing. Over the last few years, my focus has been much more on tactics and the use of force. I've written articles on tactics. I've written book chapters on reviewing use of force. I have, with a couple of co-authors, a book on evaluating police uses of force. So that's been my primary focus over the last few years.
So this is going to seem really redundant, but what is the title of the book you've authored?
It is creatively titled Evaluating Police Uses of Force.
And when did you publish that book?
That was published in April of 2020.
Are there other authors involved in that book?
There are, yes.
Two other authors, correct?
Yes, Jeff Albert and Jeff Noble.
Professor Stoughton, are you a member of any professional organizations or associations?
I am, yes.
Can you describe those to the jury, please?
Sure. I'm a member of the American Society of Evidence-Based Policing, which endeavors to take empirical work and bring it into policing as a predicate for good policy and decision-making. I'm a member of the International Association of Chiefs of Police in the Legal Officers section. I'm a member of the American Law Institute. I'm a member of the I'm a fellow of the American Bar Foundation. There are probably some others, but I don't remember them offhand.
So are you a lawyer?
I am a lawyer. I do not practice as a lawyer, but yes, I'm barred in the state of Virginia. Thank you. I'm also a member of the Virginia Bar.
Do you also consult with or are consulted by law enforcement agencies?
Yes.
Can you describe that for the jury, please?
Sure. So I have done training for law enforcement agencies on a range of different topics, from doing presentations at the Federal Law Enforcement Training Center or the command staff at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Federal Inspectors General, training for the command staff of the Kansas City, Missouri Police Department. The trainings or focus of what I come in and talk about can vary. Sometimes it's on setting up a robust body-worn camera program for an agency that's considering that, putting together a use of force review process. I serve, this might be an association membership. I'm not sure how to categorize this one, but I'm one of the members of the Civilian Advisory Council for the Columbia Police Department. In that capacity, I provide some consulting to that agency, or at least input to that agency, as well as doing a range of talks for other law enforcement actors, not traditional police agencies. For example, last week I was giving some talks and training to the state attorney's office in Jacksonville, Florida.
That's my next question, is have you done some speeches or presentations to groups in this area?
I have, yes, quite a few.
And can you just tell us what kinds of groups you've given presentations to?
Sure. I've spoken before the Fourth Circuit Judicial Conference, a conference of judges and prominent lawyers in the Fourth Judicial Circuit, Federal Circuit, to the American Judicial Association, to judicial conferences in half a dozen or more states. South Carolina is the easiest one, but Ohio, North Dakota, kind of all over the place. To professional organizations like the South Carolina Bar, for example, to community groups or other non-legal professional organizations. All of the talks or training have been on or about policing and various topics within that.
And Professor Stoughton, have you been retained to offer expert opinions in this case?
I have, yes.
And have you been retained as an expert before this case?
Yes.
And that is an expert in the area of policing and law enforcement?
Yes, police procedure, investigations, tactics, and the use of force primarily.
And how many times have you been retained as an expert?
I believe my current retentions are in the mid-80s. I think 84, but I may be off one or two.
Have you testified in court as an expert?
I have, yes.
And can you describe what courts you've done that in?
Yes, I've testified in both federal courts and state courts in the context of both civil matters, civil lawsuits, and in criminal proceedings.
And when you are retained, you were retained by the state in this case, correct?
Yes.
When you are retained, do you charge a fee for your services?
I do.
And what are your fees?
It will depend a little bit on the nature of the entity that that retains me. In this case, I have a $290 an hour fee, and on days when I'm expected to testify, a 10-hour flat rate.
And to date, have you been compensated for your work in this case?
Yes, I've been compensated for hours worked, I think, through November.
And approximately how much have you billed so far?
I would have billed, I believe, 34 or 35 hours, and I would have to do that math somewhere in the area of $9,000, I believe.
When you have been retained, have you always reached an opinion favorable to the party that hired you?
No, certainly not.
Why is that?
Your Honor, this is irrelevant.
The objection is overruled. The answer?
Can you repeat the question, please?
Why is it that the opinion you reach is not always favorable to the party that hired you?
It depends on the facts of the particular case. When a party hires me, when a litigator in civil or a criminal proceeding hires me, they're hiring me to apply a professional standard, that is to compare what an officer or officers or an agency did and to contrast that with the standard that you would expect an officer, or rather that I suppose would expect an officer to meet, whether they've satisfied the professional standard of care, as the term sometimes is used. And in some cases, some number of cases, my review simply has not been helpful to the attorney who's hired me. Sometimes that's a plaintiff's attorney who is suing an officer, and my opinion is that the officer acted reasonably and appropriately. Sometimes that's a defense attorney who's defending an officer in a civil or criminal lawsuit, and my opinion is that the officer acted inconsistently with generally accepted police practices. The exact reasons, of course, would depend on a particular case, but in essence, I'm not being retained to give an opinion that is favorable. I'm being retained to review and give as objective an opinion as can be managed.
Did you seek out the state to work on this case?
No.
And have you, in fact, arrived at some opinions regarding the conduct involved in this case?
I have, yes.
I'm gonna ask you about the process you go through to arrive at those opinions. Can you first explain how you start when you're retained in a case?
Sure. So the first thing that I need to do is really understand the body of evidence or information that that applies. I need to get all of the information, either all of the information in the case or all of the information that I or the attorneys who hired me agree is relevant to the opinions that I would be forming. So the first step is really gather all the information and start looking through it.
And did you gather some information in this case? Were you provided information in this case for that purpose?
Yes, I was provided with a great deal of information in this case.
Can you just generally describe for the jury what kinds of information you did receive?
Sure. So in this case, there were several thousand pages of written documentation, training records, personnel records, among others. There were videos from officers' body-worn cameras. There were videos from squads, from police vehicles, or in-car camera systems. There were interviews that had been conducted of some of the parties involved in the incident. There were still images, crime scene photos. There were cell phone records. There was additional information about the crime scene using sort of a three-dimensional laser modeling technique. I believe I received all of the file in this case.
Was that information, in your opinion, adequate to arrive at opinions in this matter?
Yes, it was.
In your work in this field, do you commonly review body-worn camera videos?
Yes, quite often, both as a consultant in the context of specific cases and also as a trainer and educator. One of the trainings that I have done most frequently is educating investigators, prosecuting attorneys, other parties on how to review and interpret video footage, particularly body-worn camera footage, and especially in the context of use of force investigations.
Have you done any research or publication in the use of body-worn cameras?
I have, yes.
Can you just briefly describe that for the jurors?
Sure. I have, I believe it's a 2018 article on police body-worn cameras that identifies the potential benefits of the technology, the limitations, both the limitations of the technology itself and the limitations that we have as humans viewing video footage. I have a chapter insert in a book by Eli Malm and Michael White, two criminologists, on body-worn camera footage, specifically on the review procedures of watching body-worn camera footage.
I think you just mentioned two authors.
I did, yes.
Can you spell that first author?
Yes, Michael White, both common spelling, and Eli is A-I-L-I, last name M-A-L-M, I'm pretty sure.
And is it helpful to have body-worn camera videos of the incident?
It is, yes. Body-worn camera footage can provide information that you simply would not get from another source. You have to be a little bit careful in relying too heavily on it, because body-worn camera footage, like anything else, is just one more piece of evidence to compare and contrast against other pieces of evidence. But it can be extremely valuable in the right case.
Is it also helpful to have multiple different body-worn camera videos of an incident?
Absolutely. The more video you have, the more insight you have into what happened in a particular case. Information that may not be clear on one video because of an obstruction, for example, or because an officer is moving, may be clearer on another video. Just like having multiple statements is often more helpful than having a single statement, having multiple videos allows you to draw firmer and sometimes more conclusions than just having a single video.
So in reviewing all that information that you obtained, did you rely on your training and experience when reviewing and interpreting those materials?
I did, yes.
Now, when you begin working on a case, you told us you review the materials. When you get around to analyzing the case itself, what is the sort of the first step that you undertake when working on a case?
Sure. So in a use of force case or in a tactics case, the frame that I have to use for analyzing it is the perspective of the reasonable officer in the position of the actual officer. So if you sort of imagine pulling the actual officer who was there out of the picture and putting in this idea or this construct of the reasonable officer, I have to identify what information would have been known to the reasonable officer on the scene. It wouldn't really be fair to anyone involved to assess an officer's actions using information that was not available to them or someone in their position.
And then what is the next step that you do in the process of analyzing the case?
After identifying the information that's available to the officer, the reasonable officer on the scene in the officer's position, the next step is identifying whether there was some threat that could justify a use of force. I'm using a use of force a little bit carefully here. The question isn't yet whether a particular use of force was justified. It's just whether there is some threat that justifies some use of force in response.
And then what is the next step that you do?
So after identifying the foreseeable effects of the threat, then the question turns to the officer's response. It requires looking at the officer's actions and identifying what are the foreseeable effects of the officer's actions. An officer's use of force can have different effects in different circumstances. So what could be a relatively low-level use of force in one case might be a relatively high-level use of force in another case. I have to look at the facts and circumstances, again through that framework of a reasonable officer on the scene, and identify what the reasonable officer would have thought the likely effect of their actions would be.
And for the last step in the analysis, what standards do you apply in making that determination?
The ultimate standard that I'm using is the professional standard within policing. Policing draws on, as an industry, a bunch of different standards. It draws on some Fourth Amendment law, it draws on state law, it draws on some research, it draws on historical practices within policing. So what I'm looking to determine what the foreseeable effects of force are, it's really what would the professional officer in this situation have perceived, what would the reasonable officer in this situation have thought the foreseeable effects are going to be. That would include the training that officers get, that would include agency policies, anything that helps inform that expectation on the officer's position.
If an agency has policies, how does that contribute to the standard you've just talked about?
Sure. So policies are effectively rules or guidelines that help provide guidance to officers in the performance of their duties. If officers did everything perfectly all the time, you wouldn't need policies to tell them what to do or what not to do, right? You could just send them loose and everything would be fine. So when you're analyzing, or when I'm analyzing, what the foreseeable effect of a particular use of force is, for example, one of the inputs, one of the factors to consider is what the officer has learned at their agency about that particular use of force. Sometimes there are things that I would describe as generally accepted in policing, that is, policing as an industry knows about something, but the officers in this case may have been badly educated. I say this case to refer, of course, to the hypothetical that I'm talking about, not any case in particular. If officers just simply don't know, in fact, I had a small role working on a case like this out of South Carolina, if officers simply don't know about this risk because it's outside the scope of their policy and training, then although there might be a violation of generally accepted police practices, that would fall more on the agency than on the officer. On the other hand, when there are risks that have been identified in policy or in an agency's training, then it should be clearer that the officer has some awareness, or certainly should have some awareness, of what those foreseeable effects or those risks are.
Are you familiar with an organization called Lexipol?
I am, yes.
And what is Lexipol?
Lexipol is, until relatively recently, Lexipol was primarily involved in creating and marketing policy manuals for police agencies. An agency could go to Lexipol and purchase off the shelf a set of policies that it could then take and append and revise as the agency saw fit. A little more recently, Lexipol has gotten into the training and commentary space. They've purchased a media publication website that used to be Police One and is now called Police One by Lexipol, as a way of publishing op-eds or information to a police-oriented audience.
So is obtaining policies, foreign policies from Lexipol, a reasonable thing for agencies to do?
It certainly can be, yes. Lexipol refers to case law in the specific state where the agency is located. It refers to Supreme Court or Federal Circuit case law. Lexipol tries to take some of the work of creating policies, well, out of the process of creating policies. It tries to provide a more standardized basis for agency policies, both in terms of content and formatting. Although I think there are reasons that agencies might want to particularize some policies much more closely than sometimes they do with Lexipol, as a way of sort of setting a fundamental baseline. I think the Lexipol policies are generally consistent with accepted police practices.
Now, you mentioned earlier the constitutional standard for police uses of force, correct?
Yes, one of the factors or one of the inputs that informs the professional standard within policing is certainly the constitutional law and the Fourth Amendment.
And what is that standard? Can you describe it? Give the jurors a brief primer about that, please.
Sure. So in 1985, the Supreme Court decided a case called Tennessee v. Garner, which was a deadly force case. And in that case, the court held that for officers to use deadly force without violating the Fourth Amendment, officers had to have probable cause that the subject against whom force was used presented an imminent threat of death or great bodily harm to the officer or someone else. 5 years later, in 1989, 4 years later, in 1989, the Supreme Court decided a case called Graham v. Connor. In that case, the court held that with regard to other uses of force, what are referred to generally as less lethal uses of force as opposed to deadly force, although the court didn't use that language, that in order to comply with the Fourth Amendment, those uses of force must be objectively reasonable. It provided some guidance on how to make that assessment, as well as the framework that I mentioned before. The question of whether an officer acted in an objectively reasonable manner is a determination that's made from the perspective of the reasonable officer on the scene.
And were there some particular factors the court drew out in Graham that informs the determination of the reasonableness of force?
Yes, the Supreme Court identified a series of three non-exhaustive factors that are now referred to often as the Graham factors. That's the severity of the underlying crime, whether the individual is attempting to flee or evade arrest by flight. Whether the individual is actively resisting or attempting to evade arrest by flight, and whether the individual presents a threat of harm to the officers or others.
Now, in this, from both of those cases comes the word threat, correct?
Yes.
And based on your training and experience in this field, when you use the term threat, how would you define threat?
Sure. So a threat, or particularly the concept of imminent threat, can be distinguished from another concept that I'll refer to as risk. A threat exists, or a threat is imminent, when the reasonable officer on the scene would perceive the individual in question as having the ability, opportunity, and intention to cause a particular type of harm. I want to focus on that particular type of harm for just a second. In policing, there really should never be such a thing as a threat generically. It's always a threat of something, a threat of escape, a threat of harm, a threat of death or great bodily harm. And that's because figuring out, under the second prong of that analysis that I talked about before, figuring out the foreseeable effects of the threat presented, whether there's an imminent threat, my train of thought got completely derailed. Figuring out whether there is an imminent threat of a particular type of harm becomes important when you try and figure out whether the officer's response, the use of force, was proportional to that threat or not. So just because someone presents some kind of threat does not give officers, obviously, carte blanche to do anything. Their response has to be proportional and appropriate.
And how does that different than the term risk?
Sure. So with an imminent threat, we have ability and opportunity and apparent intention to cause a particular type of harm. Ability is when someone has the physical capability of causing this particular type of harm, right? Someone who's physically running away has the ability to threat, right? The ability to flee. Someone who is holding a baseball bat has the physical ability to hit someone with the baseball bat in a way that someone without a baseball bat obviously does not have the physical ability to hit someone with a bat. Opportunity really refers to whether someone is vulnerable to that particular type of harm. Sometimes it's referred to as jeopardy. Someone who has a baseball bat may have the ability to hit someone with that bat, but if they're 50 feet away from the nearest person, they don't yet have the opportunity to hit someone with that bat. Now, as they close distance and come closer, then sure, they could develop the opportunity, but at that moment, while they're 50 feet away, they do not. And apparent intention is really behaviors indicating that the person wants to cause that particular type of harm. Someone who has a bat and is standing very close to someone else, but they're in a batting cage and he's practicing batting practice, really has no intention to strike someone with that bat. So you need all three to have an imminent threat. When you don't have one of those three things, when you have one or two but not all three, we would refer to that as risk. And officers can use a range of tools to manage risk, but they can't use force to address risk. So if an officer wanted to talk to someone with a bat in that batting cage, the officer might ask the person to put the bat down. The officer might stand on the other side of a fence where they can't be hit with the bat, but they couldn't use force because that person happened to be holding a bat in that circumstance.
You've been discussing this, the standards that sort of apply here to the reasonable use of force. Did you look at Minnesota statutes that deal with the use of force?
I did, yes.
And are they consistent with the legal standards you've been describing?
Yes, there are certainly no inconsistencies. The language used in the state statutes are obviously a little different than language used in the Fourth Amendment case law, but they are broadly consistent, yes.
And did you review Brooklyn Center Police Department policy on the use of force?
Yes, I did.
And is that also consistent with these standards?
Yes, it is.
You mentioned earlier a third step in the process of considering the foreseeable effects of the officer's use of force. Can you explain why that's part of the analysis?
Yes, absolutely. So that gets us into really the fourth step in the analysis. The second step is looking at the threat that the subject presents, if any. The third step, looking at the officer's response. And the fourth step is sort of weighing one against the other, determining whether the officer's response is proportional to the threat being offered. The concept of excessive force, for example, is a way of describing when an officer's use of force is disproportionately high compared to the threat presented by the subject. There are some other factors that go in, but that's essentially the nutshell. you need to figure out what the foreseeable effects of an officer's actions are and weigh them against the foreseeable effects of the threat presented, if any, again, by the subject.
And when you talk about using force and deadly force, is shooting a gun at somebody considered deadly force?
It is, yes.
Why?
The foreseeable effect of discharging a firearm at someone is that it will cause great bodily harm or death. And one of the important things to keep in mind about that is we're talking about the foreseeable effects of the officer's actions, not the effects that actually occur. For example, if an officer shoots at someone but misses, or shoots at someone but causes only a superficial wound, just scratches their shoulder or something like that, we would still consider that a use of deadly force because the foreseeable effect of discharging a firearm at someone is death or great bodily harm. And the definition in policing of deadly force is force that has a substantial likelihood of causing death or great bodily harm.
In the cases that you've been talking about, is there language about hindsight?
Yes. In Graham v. Connor specifically, the court counsels against using what it calls the 20/20 vision of hindsight. That's in the same portion of the opinion where it's reminding courts that are reviewing uses of force that an officer's use of force has to be evaluated from the perspective of the reasonable officer on the scene at the time that force is used, and without adopting the 20/20 vision of hindsight.
In other words, the analysis has to be limited to what set of facts?
The analysis has to be limited to the facts that were available to the officer at the time. You can't bring in facts that are later determined to be true if the officer was not aware of them. So, by way of example, if someone is stabbing at an officer with a rigid, shiny object, and the reasonable officer on scene would think that's a knife, then for purposes of analyzing the use of force, you look at that threat as if it was a knife, even if, after the incident, it's determined that it was really a harmless plastic toy. And in the same vein, if an officer, for example, tells someone to put their hands behind their head, and the person puts their hands behind their head, and it turns out that they have a sword tucked into the back of their shirt, and they're going to whip it out and cut the officer with it, if the officer doesn't know that at the time, then the use of force would be inappropriate, because so far as the reasonable officer and the officer's position is concerned, the person is just complying with exactly what the officer told them to do. So that concept of not using the 20/20 vision of hindsight is really a stern reminder to not bring in information that the officer was not aware of at the time.
All right, now I want to turn to the opinions that you've reached in this case, okay?
Sure.
The first thing I want to go over with you is Officer Potter's use of deadly force. Is her conduct in firing her Glock at Mr. Wright a use of deadly force?
It is, yes.
Why?
Again, firing a firearm, discharging a firearm is substantially likely to cause great bodily harm or death. That is the definition of deadly force.
And in your review of all the materials in this case, did you see any evidence that Officer Potter decided to use a gun in this case instead of a taser?
Did I see evidence that she decided to use a gun? I think the evidence that I've reviewed suggested that she intended to use the taser and not the firearm.
When you're reviewing, then, the use of deadly force, are you reviewing that act or a decision? Does that make sense?
I think so. If I understand your question, it's really what's the nature of the actions I'm evaluating.
Right.
I am evaluating the use of deadly force because that is, in fact, the force that was used. I separately have an opinion related to the use of a taser, which is what I understand Officer Potter intended to use in this case.
Earlier, when you were describing the standard, you in this hindsight 2020 thing, you talked about what known by the officer at the time, and I meant to follow up on that. At the time of what?
So known to the officer at the time that force is used. For example, just because a person does something at point A does not mean that officers can use the amount of force that would have been justified at point B. The circumstances may have changed. We are talking about dynamic situations. So the question is whether the particular use of force was proportional, and separately whether it was appropriate at the time that force was used.
In this case, have you reached an opinion to a reasonable degree of professional certainty whether Officer Potter's conduct in using deadly force was reasonable and justified?
I have, yes.
And what is that opinion?
The use of deadly force was not appropriate, and the evidence suggests that a reasonable officer in Officer Potter's position could not have believed that it was proportional to the threat at the time. In other words, the use of force was apparently excessive and inappropriate.
And specifically, the use of deadly force.
I'm sorry, yes, the use of deadly force.
In your review of all the materials, is there evidence that Officer Potter herself did not believe that there was an imminent threat of death or great bodily harm?
I apologize. Would you ask that question again?
Sure.
I almost knocked over the monitor.
In your review of all the materials, is there evidence that Officer Potter herself did not believe there was an imminent threat of death or great bodily harm at the time she shot her gun?
Before you answer, excuse me, Your Honor, I object to that. Answer to that is giving an opinion of the client's.
Okay, counsel, that's enough. No speaking objections, please.
All right.
The objection is sustained.
In formulating your opinion that you just told us, did you consider whether there was evidence about whether Officer Potter believed there was an imminent threat of death or great bodily harm?
Same objection, Your Honor.
The objection is sustained.
In formulating your opinion in this case, Professor Stoughton, is it necessary for you to determine whether there was an objective, whether a reasonable officer would have objectively believed there was an imminent threat of death or great bodily harm?
Yes.
And would evidence of the officer's actual conduct be indicative of or relevant to an objective standard of whether there was an imminent threat of harm, death or great bodily harm?
It would, yes. The phrase that...
Object, Your Honor. It's asked and answered.
The objection is overruled. You may finish your answer.
Thank you, Your Honor. The phrasing that is used in some of the literature as well as our book is referred to as, confusingly, as subjective objectivity. We're evaluating whether use of force is objectively reasonable, for example, but we do so by taking into consideration the subjective impressions of the officer. Again, that's part of the framework of the reasonable officer on the scene.
And so in arriving at your opinion, was it necessary for you to consider the subjective knowledge of the officer on the scene, Officer Potter?
Yes, it was.
And then in arriving at your opinion that it was not a reasonable use of force, of deadly force, did you see any evidence that would lead you to believe that Officer Potter had knowledge of circumstances that would create an imminent or support an imminent threat of death or great bodily harm?
Objection, Your Honor. Improper opinion of the witness.
Okay, the objection is overruled. I'll allow that. Yes. Okay.
Thanks for tuning in, everyone. So we're on day 10 here. Seth Stoughton is an expert in police use of force. So we've been hearing from him. So earlier today, obviously, the other officer had, been in front of Kim Potter for quite some time, and that definitely came across in that way that testimony went. And so what we see is, the defense tries to build reasonable doubt in the jury and connect with them on that. And so we see, like, insurance, for example. Even though lots of times there's encounters about insurance, they try to focus on that, or worrying about cannabis, or the primary moving offense in Minnesota of air fresheners. So, they're just trying to reach wherever they can to get that reasonable doubt going. And as I mentioned before, with Geronimo Yanez, they were, Earl Grey was able to get Yanez off because Yanez said all these things about being afraid of cannabis, and they were even able to keep that jury in the Philando Castile case away from being able to review that BCA transcript. This lawyer did that. So that's how this works in Minnesota is, that kind of transcript wasn't even available in the Yanez case to those jurors. So I feel that that's relevant here because same lawyer, similar tactics going on. So I'll just mention, we have some updates. Derek Chauvin pleaded guilty, federal court. This could conceivably lead him to him serving more time than he was going to just in the main state charges. The other police officers that were at the killing of George Floyd are still up on civil rights charges, and according to the AP, Chauvin also pled out to attacking a teenager and depriving them of civil rights, and he pled out on guilty on one of those charges as well. So, which again shows that the Minneapolis Police Department was not giving adequate oversight to this man before George Floyd was killed. So that's moving through, that's been looked at in court in St. Paul. I believe Judge Magnuson has been looking at that today, or it may have been yesterday, sorry. 1 second. So we're still waiting, long sidebar. So, if you can take a look at our website, unicornriot.ninja. We got the Kim Potter trial landing page. That's been updated. We've got a new story up this morning, both about community members with messages for Daunte Wright's family. We also have one from one of our contributors in Brazil has an update about Bolsonaro, the president of Brazil, committing crimes against humanity, finds a commission. So we've got info on that, some international coverage there, global coverage, as we're waiting on this long sidebar. And it, another, we were looking, the guy mentioned Lexapol, Mr. Stoughton mentioned Lexapol, and it's interesting, I found a story, the Texas Law Review did a report about Lexapol saying, is this an example of privatization of regulation of police, fobbing off, the development of regulations to private organizations. The Texas Law Review does have a story about Lexapol if anybody's curious about learning more about Lexapol, because there's a lot of different dimensions of police policy involving these orgs. International Association of Chiefs of Police, the Emergency Management Assistance Compact that moves police around between states, like the Minnesota Police and Peace Officers Association, MPPOA. I've seen them lobby to keep medical conditions off of the cannabis bill. I've seen that in person, right next to me, when medical cannabis came through in the Minnesota legislature. So there's all these different levels to policing, and you could hear the rationalizations coming through from some of these witnesses, some of these officers especially, about how they can think it's reasonable to escalate violence in situations, or sort of have sort of an aura of threat hanging over everything. And so, that building that up has just been such a major recurring theme with the defense in this case. So this has been a pretty long sidebar here, but I wanted to throw those things out there real quick. One of the commenters is arguing that, sidebars shouldn't be secret and the reasoning should be public and all of that. And, the reality is that, like, judges speak on the record in cases in a very formal fashion, and I think any lawyer can tell you that the tone and the way that they communicate in their chambers or in sidebar can be very different than what is out to the public, even when the jury is not in the room. So if this is going on, I can try to have a couple questions, but, I didn't go to law school. Like, I've been learning quite a bit about how this whole game works, as much as all of us have, watching these trials. Although I do have experience with reporting stuff like legislative politics and lobbying and stuff. I've seen a lot of that. So from my personal experience, I can at least bring something to bear about the other policy levels that happen outside of court level. Judicial branch. So let's see. And again, I'll mention again, we had Mr. Stoughton. He testified in the Derek Chauvin trial. I believe that was day 23. So I put up a link for that on our Twitter. Looks like they're all digging around. This is taking a minute. So you can see, again, Kim Potter benefits from this new COVID headphone system for sidebars, right? Like, typically, sidebars wouldn't usually have the defendant approach the bench as well, if I'm not mistaken. So this helps her to kind of keep tabs on this. Like, obviously, she gets pretty engaged when these sidebars were going on. So let's see what else.
Excuse us.
Yeah, and one of the commenters points out that, like, the judge hasn't been too stern with the defense attorney. I think they're making the jury leave.
Okay, you may step down, Professor. Okay, I didn't want the jury waiting, and I do think we need to discuss this a little further on what I'm going to allow this expert to testify to. First of all, initially, I'm not going to let him express opinions that were not previously disclosed. Okay? So, Mr. Frank, right now, can you show me where his opinions are concerning the subject that you were on, particularly with respect to his opinions regarding subjective considerations?
Yes, Your Honor. If you would look at Professor Stoughton's report, starting on page 37, the heading itself expresses the opinion that he just gave here in court about the use of deadly force. In that, he goes on to explain that that Officer Potter drew her firearm, even though it appeared that she meant to draw her taser. She drew her firearm, and that opinion, that it was an unreasonable use of force, is informed by a number of factors. One of them is the question of whether a reasonable officer in her position would have believed that an officer, specifically Officer Johnson, could have been harmed, whether there is an imminent threat of harm. And it goes on, page 39. I'm sorry, did I? Yes, through page 38, on to page 39. And into whether that opinion, or whether a reasonable officer in that position would have believed that there was an imminent threat of death or great bodily harm. And he points out the available evidence, and this is the bottom paragraph on page 38, suggests that Potter intended to use her taser. And he explains her subjective conduct. He doesn't use the word subjective, but it explains her conduct. This is all, and then what happens after. What the officers were doing, the other officers, making a decision to go into a vehicle, which is generally not what officers are supposed to do. We heard that testimony earlier. This is all conduct that is corroborative of what she knew at the time. A reasonable officer in her position would have known. It's corroboration, and that's why it's in here. It's all presented here through page 39 and then to page 40. So the court has allowed defense counsel to ask several witnesses if she could have used if she could use deadly force to shoot him, and that's obviously going to be an argument they're going to make. Professor Stoughton to counsel months ago, and that's what I'm where there was an imminent threat of death or great bodily harm. So, would a reasonable officer in her position have known that, justifying deadly force? Well, what did Officer Potter know? What information did she have? Okay? So we have to look for evidence of that. The evidence of that is her conduct before, during, and after, as well as some other things. That's all discussed here. So it's corroborative of what a reasonable officer in the position would have known, what information she had. And so that's because that's what we have to do, right? We can't ask her. And so we are proving it by evidence from the case. That's why I asked him, is there evidence? And so that's why I did it that way. It's to support his opinion.
Okay.
Well, I don't see anything about subjective in that regard. Plus that, he's making this opinion based on the fact that Johnson wasn't in the vehicle. So, come on, include Johnson in the vehicle and be fairest to the testimony. In this case, two officers, Johnson, who was there, said he was in imminent danger, and Commander Westland said the same when I gave him a hypothetical. And he's never seen this, that he would be in imminent danger. So now we have an expert in here, and the prosecution is asking him a question without including the fact that the witness in this case, the man who was there, said I was in the vehicle, and yes, I was in imminent danger. I could have been dragged. We have more witnesses coming, Your Honor, but for him just to give an opinion without including Mr. Jackson and trying to use my client's subjective, what she said when she doesn't even know she said it, it's not fair.
Okay, Mr. Gray, you can bring that out in cross, and I'm sure that you will.
Oh, I'm sure I will too, but is he allowed to give an opinion without all the facts?
Well, that's what cross is for. And I think the problem that we're having is the word subjective, because he can't really testify he can testify as to what a reasonable officer would have done under the circumstances. And I think in his opinion, he also states deadly force is limited to those situations in which there is probable cause to believe that the subject presents an imminent threat of death or great bodily harm. So I think the state can bring out facts and have him testify as to the facts that would justify a police officer thinking that this that the situation presented a serious threat.
And Your Honor, I'm sorry.
Go ahead.
You're absolutely right. The question is not really whether Officer Johnson was in the car. The question is whether a reasonable officer in Officer Potter's position perceived him as being in the car such that it would present an imminent threat of death or great bodily harm. That's what we're trying to explore. So her subjective conduct, not her subjective state of mind, but the actual conduct that she does is corroborative and explorative of that, and that's why we're going to. It's part of his opinion. So,
Okay. Well, if he bases his opinions on the facts and not speculate as to what she was thinking.
I'm quite confident that Professor Stoughton knows not to talk about her state of mind.
Okay.
He is going to talk about her conduct.
Okay. I think that's
Doesn't he
fine.
have to- Doesn't the witness have to base his opinion on the evidence in the case such, and not his vision of something in a video or what he thinks? It would seem to me that the opinion would be unfair even before I cross-examine him, unless he includes that.
You know, I think that's subject again of cross-examination. Okay, so are we clear on where we're going?
I am, Your Honor, and I believe, and I will just take a moment to instruct the witness not to talk about her subjective state of mind. But to be clear, I guess, wanting to clarify this, his discussion of the conduct leads to evidence about knowledge of a reasonable officer at that time. Not about what she's thinking or intending, but what that says about knowledge of an officer in that position.
Right. Okay. I think that's fine. Because he's basically going to be restricted to testifying concerning if a reasonable officer in that position would have probable cause to believe that the subject presented an imminent threat of death or great bodily harm based on the facts. And then Mr. Gray, of course, can bring out the fact that, you know, this professor didn't have all the facts when he rendered that opinion. Okay, let's bring the witness back on.
So thank you for joining us. So we've been hearing from Seth Stoughton, who is a expert in use of force. He was testified at the Derek Chauvin trial earlier this year. You can go back to our YouTube archive. I believe it's on day 23. So we're watching this development. Derek Chauvin has also pleaded guilty in federal court to civil rights charge violations, not just against George Floyd, but also against a teenager. So there's really two different civil rights federal cases coming up with Chauvin himself. So that's been going on. So we're waiting a minute. I think the jury is going to be coming back. So we'll take a
Thanks,
second.
Deputy.
That's Seth Stoughton, who's pretty articulate witness for the prosecution. He, unlike some of these witnesses, was not a life, career friend of Kim Potter, unlike some of these other witnesses have been. And so you've heard how the defense is trying to keep his testimony as trimmed as possible. Again, we're on day 10. We think we're coming to the end of the prosecution case. So we think that, I think someone from the family is going to give a spark of life testimony at the end, and then the prosecution's going to rest its case. That could happen later today. So it's 12:04. We've got about 25 minutes left, so I bet the cross could start maybe after lunch. We will be going down. I'll play some more of the footage from April 12th, and we could be going down, we will be going down because of technical limits with Facebook. So we'll then come back about 10 minutes or so before court resumes on the lunch break. So we got that going on. Thank you all for joining us. Again, if you can share our work out there, that definitely helps. It's much appreciated. Our website, unicornriot.ninja. And you could definitely send a donation. someone in Minneapolis sent in $100 like yesterday. That's really appreciated. You know, we've been really trying to work hard on this. We're a small group, but we've been trying to, you know, bring this out to folks because it is, you know, there's major social significance to what police do. Here comes the jury. Everyone stands for the jury. Let's see. The jury's coming back.
Okay, please be seated. Mr. Frank, you may continue.
Thank you, Your Honor. Professor Stoughton, let me start out this way. In assessing or arriving at your opinion about whether the use of deadly force was reasonable, proportional in this case, did you attempt to identify any threat of imminent great bodily harm or death?
Yes.
And were you able to identify any potential such threats?
Certainly risk, yes.
Explain.
So from my review of the evidence, Sergeant Johnson entered or leaned his torso into Mr. Wright's vehicle and stayed in that position for approximately 8 seconds. An officer who overextends themselves by putting themselves into someone's vehicle certainly has the potential, if the vehicle begins moving, to be dragged, ejected, seriously injured, killed, run over by the vehicle, or the like. That's always a risk. As I talked about earlier, it doesn't become a threat until there's ability, opportunity, and intention, but it's always a risk of reaching into a vehicle.
And so in determining whether that risk was an actual threat from a reasonable officer in Officer Potter's position, did you look at evidence from the case itself?
Yes, of course.
And in doing that, is evidence of conduct, actual conduct of the officer, corroborative? Does it corroborate what a reasonable officer in that officer's position would have known?
Yes, absolutely. So, for example,
Excuse me, Your Honor, can you answer the question?
Okay. All right. All right. The objection is sustained.
Would an example help explain your testimony?
I think so.
Okay. Tell us what the example is then, please.
So, for example, if there are the sound of gunshots on a video, like an officer's body-worn camera video, and the question is whether the reasonable officer in that situation would have perceived that those gunshots were actual gunshots or a car backfiring or a nearby television or something like that. You look at the actions of the people around, including the actions of the officer, to help figure out what conclusions the reasonable officer on the scene would have drawn. If, for an example, with that same example, if the officer remains standing casually leaned against a wall with their arms crossed and really doesn't react, it would tend to suggest that the reasonable officer in that situation would not draw the conclusion that those were actual gunshots that merited an immediate response, for example.
So in evaluating whether this risk created by Officer Johnson's conduct had become an imminent threat, did you consider the conduct of Officer Potter?
I did, and particularly the question as to whether it would have been perceived as by the reasonable officer in Officer Potter's position as an imminent threat. Yes.
And what conduct did you consider, and explain how that affected your opinion?
Sure. In summary, the conduct that is relevant is conduct immediately before and during the shooting itself, and then immediately after the shooting. So with a little bit more particularity, The conduct before the shooting is Officer Potter's apparent decision to use the taser. She threatens twice, "I'll tase you, I'll tase you." She draws a weapon that is her sidearm, her firearm. She gives taser warnings, which is taser, taser, taser. That's in small part a warning to the subject, but it's really a warning to other officers that there's about to be a taser discharge. And then she pulled the trigger of the firearm, aiming it in the area of Mr. Wright's chest. Immediately after the shooting, Officer Potter indicates that was not what she meant to do. She says something to the equivalent of, "Oh shit, I shot him, I drew the wrong gun, or I pulled the wrong gun, I shot him." And then in the next few minutes,
Any more of his narrative regarding what you said after that as indicating something?
The objection is overruled. You may continue.
Thank you, Your Honor. In the next few minutes, there are additional indications that Officer Potter, at least, or rather, there are additional behaviors that would indicate that a reasonable officer in her position at the time would not have perceived that there was an imminent threat of death or great bodily harm, most especially her statements about going to prison, indicative that there was a lack of justification for the use of deadly force.
And is there additional indications there at the scene involving what I would like to call backdrop when she actually fired?
Yes. So immediately before the time she pulled the trigger and shot, Officer Lucky was standing immediately to her right and extending over, sort of reaching into the open driver's side door. There was obviously a passenger in the car. And until the time Officer Potter began saying taser, 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 we have that 8-second period of Sergeant Johnson leaning his torso into the vehicle as well. In other words, we're talking about a number of potential targets that could be struck with a bullet in very close proximity. It's generally accepted in policing that officers actually miss their target more often than they hit, so they have to be very aware of what's immediately around their target. It's also well known that bullets can overpenetrate, so officers have to be very aware of what's immediately behind their target. Putting that together, the indication of the putting together the behavior indicating taser, the intention to use a taser, and the rationale that would militate against firearms use, reasonable officer in that situation would not have believed that there was an imminent threat of death or great bodily harm, or maybe a little bit more precisely, those actions are certainly not consistent with the actions of a reasonable officer who perceived an imminent threat of death or great bodily harm.
Now, we've been talking about, well, let me back up just a bit. We've heard some testimony about hollow point bullets. Are you familiar with them?
Yes, I am.
And what is at least one of the purposes of a hollow point type bullet?
A hollow point bullet has a small indentation, on the front that causes the head of the bullet to expand, or it's sometimes called to mushroom, when it penetrates especially soft target, like bodily tissue. There are a couple of different reasons for that. One is to increase the stopping power, the actual kinetic power of the bullet. To the more surface area it takes up, the more kinetic energy it transfers from the bullet that's moving into the body of the person, as opposed to what's called a fully jacketed bullet, which has a shell around the lead of the bullet that just might pierce through someone. So one reason for a hollow point bullet is to have more what's referred to as stopping power. Another reason is to reduce the likelihood of overpenetration. When the bullet expands, the idea is it will stop sooner than a different round, a non-hollow point round.
And you talked about one of the concerns of firing the weapon, the gun, in this case. Would the fact that Officer Potter fired a hollow point bullet have ensured that it would not have presented a danger to others in that immediate area?
No, absolutely not. Hollow point bullets are a pretty standard issue in policing. There are still overpenetration issues in police shootings. And of course, if a hollow point bullet hits a relatively small target, like the muscles of the upper arm, for example, it's probably not going to stop. In fact, it's almost certainly not going to stop there. It's going to overpenetrate. And of course, if it misses the intended target and hits another target, well, then the fact that it's a hollow point doesn't help you at all.
All right, so I want to explore this issue about Sergeant Johnson being in the vehicle a little further. And I want to have you assume, for purposes of this part of the analysis, that a reasonable officer in Officer Potter's position was aware that Sergeant Johnson was in the vehicle to some extent, okay?
Okay.
Right. And I'm going to put up on the screen what's been received as Exhibit 63. And I'm going to ask you just to pause it for a minute, Mr. Miller, and could you freeze this video at the timestamp of 2:01:52, please? And if you want to just go right to it, that's fine. Go a little further, please. All right, so that's fine. Are you familiar with this video?
I am, yes.
Does this appear to be Sergeant Johnson's body-worn camera video?
Yes, it is.
And we've stopped it at 2:01:52. Are you able to determine what Sergeant Johnson is doing with his right hand at this time?
Yes, Sergeant Johnson appears to be reaching for the shifter with his right hand.
And you've watched the video. Does he eventually succeed at putting his hand on that video?
Yes, he does.
And then if you could, Mr. Miller, just let this run to 2:01:54, please.
Excuse me, Your Honor, I object to his narration of an exhibit and what he perceives it to be.
All right.
Sorry.
The objection is overruled. I'll let you answer.
So again, if you could just run that through 2:01:54, please. And do you see Mr. Wright's hands there?
Yes, I do. Or at least what appears to be his right hand.
And he is trying to move the shift knob?
Yes.
And does Officer or Sergeant Johnson prohibit that, to keep it from happening?
Yes, he does.
And then if you could run this to 2:02:00, please.
Just stay back.
And if you can just click it a little bit further, please. Now at this point, can you see what Sergeant Johnson is doing?
Yes, I can.
And are you able to see Sergeant Johnson's, what do you perceive him as doing in this situation, Sergeant Johnson?
So As Officer Potter says, taser, 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 Sergeant Johnson's torso is coming back and out of the front passenger side door. His feet are on the ground there. Both of his hands are on the passenger, or at least in the direction of the passenger. I can't make out from this frame exactly what he's holding.
And does he appear to have hold of Mr. Wright?
I don't. I'd have to watch the video. I'm not sure whether he's holding Mr. Wright's hand there as the fingers, or I believe those are Mr. Wright's fingers, but I'd have to watch it to make completely sure.
So during this course of events, was Mr. Wright able to drive the vehicle?
Not with Sergeant Johnson preventing the vehicle from driving, as evidenced by the fact that the vehicle didn't move until later.
And so in your opinion, if a reasonable officer in Officer Potter's position had been aware of these facts that we've just seen regarding Officer Johnson, would it have been reasonable and proportional for an officer to use deadly force on Mr. Wright there?
No, not at this point. There was certainly some risk while Mr. Wright was scrambling for the shifter to put the car in gear. Once Sergeant Johnson has backed out of the vehicle and is no longer at risk of being dragged or carried away or anything like that, then there is no threat to him of the vehicle moving at that point.
And if you could let this run to 20201, please. At this point, can you see Sergeant Johnson's position?
Yes.
And where is he located at that time?
Sergeant Johnson is physically outside of the vehicle except for his hands, which are still maybe slightly inside the vehicle. His feet are outside the vehicle. It would appear from the frame his shoulders are outside of the vehicle.
In your opinion, if a reasonable officer in Officer Potter's position and was aware that the warnings about the taser caused Sergeant Johnson to back out of the vehicle, would it have been reasonable and proportional for an officer at that time to use deadly force?
No, it would not have been proportional because there is no longer an imminent threat of death or great bodily harm to Sergeant Johnson. He's at no threat of being dragged by the vehicle once he's out of the vehicle.
So in order to have used deadly force when the shot was fired, a reasonable officer in Officer Potter's position would have had to know that Sergeant Johnson was in the car, correct?
Yes.
That and a reasonable officer in Officer Potter's position would have not been able to perceive that Sergeant Johnson had prevented Mr. Wright from moving the car?
That's correct. The reasonable officer would have had to mistakenly believe that Sergeant Johnson was, that there was still a threat that the vehicle could move at that point.
And the reasonable officer in Officer Potter's position would have had to fail to perceive that Sergeant Johnson had actually backed out of the vehicle.
That's correct. A reasonable officer in Officer Potter's position would have had to mistake that Sergeant Johnson was still in the vehicle and not in the position that he was shortly before and at the time the shot was fired.
Is there information in this case regarding whether a reasonable officer in Officer Potter's position would have had some awareness of Sergeant Johnson's position or not?
There is evidence that leads me to conclude that a reasonable officer in Officer Potter's position would not have been aware of that.
And what is that evidence?
There are a combination of factors. First, officers, the reasonable officer would not assume that another officer had physically entered a vehicle to that extent. There's a great deal of training and guidance to officers to not reach for shifters or keys or the like. So a reasonable officer certainly wouldn't expect another officer to do so. Second, if a reasonable officer did perceive that there was some imminent threat of death or great bodily harm as by being dragged, in other words, that deadly force was justified, what you would expect to see is an officer preparing to deploy a deadly force option, that is to, for example, potentially use a firearm there. Officers are generally trained that they should draw their firearms in anticipation of having to use them if you see an imminent threat of death or great bodily harm coming. That is, if there's a risk that could manifest or could evolve into an imminent threat of death or great bodily harm, you generally draw your firearm because lesser force options may not be sufficient to actually address that threat. And then on the back end, Officer Potter's behavior would indicate that the reasonable officer in her position would not have perceived that deadly force had been justified. If you perceive that deadly force is justified, well, then using deadly force is always some cause for concern and deliberation, but not consistent with the behavior that we see.
And had anybody indicated or verbalized that they were going to enter the car?
No, there was no verbal statement from Sergeant Johnson that he was in the car. There was no verbalization from Officer Lucky or from Officer Potter that Sergeant Johnson was in the car. Nothing from Mr. Wright or the passenger in his car.
Is there information regarding a reasonable officer in Officer Potter's position to have seen Officer or Sergeant Johnson?
Yes. So although you shouldn't mistake the perspective of a body-worn camera for being exactly the perspective of an officer. There can be differences. That is, a body-worn camera will see more than an officer sees, mostly because an officer's vision, like all human vision, is somewhat limited in focus, and on a body-worn camera, everything's in focus. But for the vast majority of the approximately 8 seconds that Sergeant Johnson was in the car, you can't really make that out at all on Officer Potter's body-worn camera footage. It's not at all uncommon. In fact, it's pretty typical in dynamic situations like this for officers to not keep as close track of each other as they might ideally like to. In this case, for example, Sergeant Potter didn't know what Officer Lucky was doing right on the other side of the car.
The objection is sustained on that, and the jury will disregard that last statement.
Your Honor, may I be heard on that, please?
Yes.
So they're going over on a sidebar with this testifier for the state, Seth Stoughton, an expert in police use of force. And as you can see, the defense attorneys are going to want to try to stop that momentum as much as they can. And it's been tough, right? This prosecution is different than the Chauvin trial because there was so much medical evidence to go over with the Chauvin trial. And with this one, the medical dimension is so much simpler. And so the defense, among its efforts to kind of build that reasonable doubt, is really trying to say, oh God, he was going to get dragged. It made sense to shoot him. And they've had a lot of luck really getting Potter's colleagues to kind of say things in that direction along those lines during this thing. So that's definitely something that Professor Stoughton is kind of breaking down, picking apart, looking at look how this officer is actually standing outside the vehicle. After she says taser, taser, he backs out. That's very important to this, to kind of break down this.
I'm going to let you go to lunch right now, and we'll get started up again at 1:30. Okay?
So now they're going to lunch break. But So that's very important to how the sort of the breakdown goes here, right? So they'll be back at 1:30 in an hour. So we're going to play some more footage from the 12th. I'm going to run that for kind of a good chunk of the lunch break. Then we'll go down, come back about 10 minutes before it starts. So that'd be about 50 minutes from now. But yeah, you can really see how, the state has to kind of try to get some initiative back on this to sort of break down the defense's attempt to kind of cloud the issue by saying, oh, it's reckless, to break down the defense's effort to cloud the jury and create reasonable doubt.
Okay, the reason I sustain the objection is that this witness cannot testify as to what Officer Potter was aware of. He just can't do that. He can't say she wouldn't have been aware. She wouldn't have been aware that he was in danger or something. Because he doesn't have any foundation for that. What he can testify to is whether a reasonable officer in Officer Potter's position would have done, but not testify as to what she was aware of. Okay.
And Your Honor, I have to admit I didn't hear exactly what Professor Stoughton was saying that drew the objection. So, but what I was trying to elicit from him is that Sergeant Johnson testified that he was not aware of what Lucky was doing. And I think the witness may have misspoke and used Officer Potter's name instead.
Okay.
But what I'm asking here, and experts are not sequestered for this very purpose. Johnson testified to that, so it's relevant to what the other side of the car would have. That's the point.
Okay. Yeah, I haven't. His opinions are fine if he's looking at the evidence and drawing conclusions based upon what a reasonable officer would have done under the circumstances. Okay. So, all right. I think that takes care of that. Why don't we break for lunch and start up again at 1:30, okay? Unless Mr. Gray wants to be heard further. Did you want to be heard further? Okay. All right.
Okay, thanks so much for joining us. So the judge said there that Professor Stoughton can't speak to what Kim Potter might have been aware of, but can sort of compare him to the platonic ideal of a reasonable officer, sort of an officer in the world of the forms in Platonic philosophy, I guess you could say. So that'll be where we come back in the afternoon here. And so, again, we've been hearing that the prosecution case is pretty much wrapping up, so maybe this could be the last expert witness, and after that it might just be something from the family. That is definitely strongly possible right now. So, yeah, as the commenters are saying, the judge keeps referring to Kim Potter as an officer when she's definitely still not. So, as I was kind of saying, right, like the defense is trying to create this feeling in the jury that, something was wrong here. Maybe it's the marijuana, maybe it's the insurance, maybe it's this officer's about to get dragged away. And so you saw that, Stoughton was starting to pull that down by saying, like, look, like this officer, his shoulders are outside the vehicle, part of his arms are still in, but the rest are not. And furthermore, the vehicle starts moving after Potter shoots Daunte Wright, right? Like, how can the defense has been laying this case that, oh, he's trying to like drive and evade or whatever, but he's moments away from completely dying, right? And so they've been constructing this very critical false thing that, oh, it's part of a car chase, blah 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 blah, as you know, as Wright is literally losing control of his body and dying, which is terrible. And it seems like they've been kind of getting away with that. And so I think that's how you see the defense assembling this case. And once again, not to be repetitive for everyone, but it's important to realize that Earl Grey was able to get Geronimo Yanez off on the Philando Castile case, partly using Yanez's really absurd statements about being afraid of cannabis, right? Like earlier. And so that, again, is why that's one of the elements that keeps coming up in this. So as you know, some commenter mentioned that the marijuana theory could come back, and I think that's pretty well put by the commenter there. So again, we will take the stream down in a little bit. I'm gonna run some more footage from April 12th, and then we'll sort of take the stream down for a little while, and then we'll come back about 10 minutes before court starts, 5-10 minutes. So we do really appreciate your support. Again, you know, we really do count on everyone kind of sharing our work out there, getting the word out to your friends. We have our website, unicornriot.ninja. We've got the Kim Potter trial landing page. You know, another court case. We were talking about federal court a little bit because Derek Chauvin just pleaded guilty in federal court. And we spent a lot of time covering the Science v. Kessler case down in Charlottesville, Virginia. Unite the Right, white supremacist organizers on trial using a legal strategy involving civil action with what's called the Ku Klux Klan Act. Interesting follow-up to the Charlottesville case. That same law, the Attorney General of Washington, D.C. is now suing right-wing groups. I believe it's the Proud Boys and the Oath Keepers. That just came out, I believe, yesterday. So we're starting to actually see the same law that was used in the Charlottesville case be put forward in other cases where you know, they're alleging, you know, violations of civil rights, which I thought that was an interesting kind of side development in the legal sphere over the winter here. And although what we saw in Charlottesville was that the federal charges landed with the hung jury, and really only the state charges resulted in findings against those white supremacist defendants. So it's hard to prove those, what we call the KKK Act. But if you want to learn about that, you can read the Unite the Right on trial coverage. We have, you know, tens of thousands of words from the live tweets, from all of that, from that court coverage. But interestingly, you know, it's hard to get access to court in the United States. And so sometimes it takes, you know, what we did in that trial was like a live tweeting, and what we've done in these other trials, you know, where we've been able to get AV access, we've been able to kind of bring that out to you. You know, it's a problem how that, like, this branch of the government is, like, for the press, is much less accessible than the executive branch, the legislative branch. It's, you know, considering these are public proceedings, it is pretty frustrating that we can't get a better access there. And I don't, as you know, as a journalist, I don't think that helps the situation. Somebody just, you know, did mention the state seal of Minnesota. That's what this logo is up here, and I'm just going to pull that up because, I mean, it has been a subject of controversy. There are a few different versions of the state seal, actually, that have different hand gestures in them. You know, I believe it's supposed to be a Lakota Indian facing left, a settler with a gun in the lower left. There are a few different versions of the state seal. What can you say about how it underscores the nature of how Minnesota is, I don't know, you know, a creation of a settler state? Like, this is, the state seal reflects that, I guess, is one way you could put it. Anyway, that is a symbol that jumps out at us during the breaks, isn't it? So anyway, all right, look, I'm gonna play the April 12th footage. We'll let this run. We'll let that run for kind of most of the break. Thanks again for joining us. I do really appreciate, you know, there's been good questions in the chat. We've been kind of processing what's going on here. And then I just want to scroll back and again mention that interesting subject that came up earlier in Mr. Stoughton's testimony called Lexipol, which now owns the website Police One. And if you search Lexipol Texas Law Review, you can see an article that identifies and analyzes the growing practice of privatized police policymaking. And we've also seen that apparently Jones Day is getting involved with creating policies for the Minneapolis police as well, now that the election's over. So we're seeing this kind of specialized, privatized process of crafting police policy normalized in the United States. So there's so many different levels to policing, and I feel like a lot of people miss a lot of these different policy levels, and I think it's great to kind of dive into that and get a better sense of those policy levels and jump in on that stuff. So anyway, we got about 50 minutes left here. Timer's running. I'm going to play that April 12th footage. We really appreciate your support. If you can support us, we're a nonprofit. It's tax deductible donations. Now is a great time to support us. You can support us also on Patreon. It's whether it's monthly, weekly, or just kind of once in a while, it does really make a difference. Having that base of donors gives us the kind of independence that we need to sort of move around on these different issues, to take on really challenging things and not just kind of go along with the status quo perspectives. You see a lot of assumptions baked into a lot of media coverage about things, and I really honestly think that the fact that our donors have been so supportive has enabled us to kind of back out of a lot of these frames of reference that are really frustrating and misleading a lot of the time. So that the donations are a key part of how we're able to kind of back out on these issues out of that standard perspective. So I really appreciate that. It makes a huge difference. So thank you all for tuning in. Appreciate the support. It's been great. We'll be back with live coverage a little before 1:30 Central. Thank you. And thank you also Nico helping out, cutting some clips today, pulling out these clips. This was Nico's recording, and he's been sort of holding down some stuff on the back end today. Thank you, Nico. This is Dan. Thank you. This is all outside the Brooklyn Center Police Department, April 12, 2001. This is about right out the front. They built that barricade during the day. Blower tactic, that kind of came over from extended Portland protests, and that was kind of classic. People scared protest tactics. There's a curfew that went into effect at 7 p.m. You are in violation of the curfew and required to disperse northbound on Humboldt Avenue toward 69th Street. Media is to assemble in front of the 6700 Humboldt Avenue.
If you continue to violate the order, the curfew order, you are in violation of an unlawful assembly. Please abide by our direction and disperse peaceably. Thank you for your cooperation and adherence to our directive. If you fail to disperse, you will be placed under arrest.
Fuck you! And the elected! And the law!
And thank you all for joining. This is Nico from Unicorn Riot. We're here live watching the police react to try to clearing out the space. Like some firecrackers being shot at the cops. Police shooting out of the Humvee. Damn. That thing had like a bunch of stuff inside of it that shot out. Two of the pieces hit the microphone. Wow, they're shooting those right, like literally over the apartment building. A great neighbor to have, I guess. The police department. You could be in your house and getting gassed. Look at these folks, they are in their house. Recording from the inside. That one's on the lawn of the person's house. Guaranteed a lot of the action is going to be moving around again to different corporate installations. People here are still steady here, about 1,000 plus. They've been moved back by the consistent munitions of the police. We have another person this time again who's kneeling. Yesterday we saw it. Today it's a different person. Yesterday, the person who got arrested yesterday at the end of the stream just was detained and ticketed. see them pushing up from the side?
Hold this line! This is for Daunte! Daunte Wright! 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 Daunte Wright!
They just shot Press a whole bunch right there in the head.
Daunte Wright! 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 Black Lives Matter!
Hearing that the cops are coming in to make a kettle.
Black Lives Matter! 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 Black Lives fucking matter! Black Lives 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 Matter!
Safari Land.
Black Lives Matter! Black Lives Matter! Black Lives Matter!
Maybe Safari Land. I can't tell. Combined systems. Tactical.
No peace! No peace! No peace! No peace!
There's a lot of munitions they've used.
April 12th, 2021.
Here's a large line of police over here. You can see downtown Minneapolis in the distance. There's still about 1,000 people out here on the sides of the building and back into a parking lot.
Good? You good?
Yep, yep.
You good?
One second, y'all. Sorry. One more second. All right, we should be good. Thank you all for being patient. We still got the line right here. It's a shield line. And there's a state trooper and DNR line. I believe some of those are DNR officers working together with the state troopers. And this is the police precinct, the police departments here in Brooklyn Center. We still have a gentleman standing up there, sitting up there, kneeling with his hands up. The police are doing their move. They got the shooters on the side shooting crowd control munitions, less lethal weapons they've been shooting. They call them less lethals. It's a 40 millimeter marker round. 40 millimeter marker round and tear gas, CS gas, HC gas, triple chasers. You want to talk at all?
What's up?
You want to talk at all?
Yeah.
How's it feel to be out there? What are you thinking right now?
It's just really sad that everything that's going on right now with the George Floyd trial, and it just happened to happen at like the same time. And I really hope that like it's not a yearly occurrence, and I really hope that the city of Minneapolis can really get everything together so we can just have another peaceful community again. It's just really sad, and prayers for the family, and I really hope we can yeah, just become peaceful and loving again.
All right. Thank you.
Yeah, man.
Appreciate that. They brought the shooters over here, taking their positions right there. State troopers stopped their line at sort of like the line of the driveway into the precinct or the police department. They stopped their line a few yards too early. Now they're moved up. Police are now aggressively moving forward. An apple was thrown at them.
Oh no, an apple! What are you gonna do? Shoot us?
You feel like big strong men right now? You don't give that look for shooting minorities?
Put the fucking gun down, bitch ass! Put the fucking gun down! Put the fucking gun down! Put the fucking gun down!
They're really itchy to shoot them, to shoot those guns. They're crowd control munitions in them. They're most likely 40 millimeter marker rounds, and they probably have a sponge marker chalk on it. So they're now trying to move this gentleman. They just arrested him. Yo, is that all the stuff? Oh, we should...
Black Lives Matter! Black Lives Matter! Black Lives Matter! Black Lives Matter! Black Lives Matter!
Hey, what up?
How you doing, brother?
All right. What's the feeling out here for you?
It's hectic out here, man. We're gonna continue to stay boots ground. This is bullshit. They assembling this shit, man. They protecting these government official buildings out here. Got state troopers, Brooklyn Center, Brooklyn Park Police Department, Minneapolis Police Department.
They tried it. They tried to pull three up. They didn't grab them. Now they're telling them, shut the fuck up, get the fuck back. As a firework goes off in the distance.
So this some bullshit, man. I got hit with a rubber bullet yesterday, so I'm vest up today. I ain't gonna have that shit. again, like I said, this is unbelievable that they're doing this to us, man. Like we did something wrong. They killed Daunte Wright. They was in the wrong, not us, man. And again, we got George Floyd trial going on. They killed Dolo Adid in South Minneapolis. They keep on murdering us, man, back to back to back to back. And they want to give us a curfew? That's bullshit. That's bullshit. So we're going to continue to be out here boots the ground, man. And this is why I say we need to continue to be pushing legislative changes and getting our brothers and sisters in the offices and these tables, because this shit right here. The people are sick and tired. The police is not here for the people. They're not here to protect and serve. We can do this ourselves then, if that's the case. CPAC, Family Supporting Families Against Police Violence, Twin Cities Justice for Jamar Clark. We got organizations out here ready to step up to the plate and do it.
And he got away. All of that, and he got away. That's the captain out here pushing people now too. That was the captain out here, right here, this last one. This is the captain, the state trooper, the captain of the state troopers right here.
We on your ass.
Very aggressive. This is Nico from Unicorn Riot. We're here live at the front line of a curfew, of the police trying to install a curfew. Excuse me real quick. Excuse me real quick.
Can I have my sweater back?
Looks like they snatched his sweater vest. So here's the line. They have multiple tactical vehicles back there. That was a pretty wild series of events right there. They tried two different times to take that gentleman in the front.
Say his name! Say his name! What did you say?
There's a water bottle. It just hit a trooper, and he just, I don't know if you can see his reaction on that. There's still about maybe a few hundred people in the background, in the distance. And there goes a SWAT type of vehicle that's being pulled behind.
Hey folks, we're going to take the stream down and kind of reset it to get ready for the afternoon session. As you can see, they're not back yet, but they're expected back. So I'll be bringing up back the stream in about 5 minutes or so. Thanks for joining us. Appreciate it. Again, this is Dan at Unicorn Riot, and Nico's been on the back end, or helping out with a bunch of other sort of little side issues today as well. If you can support our work at unicornriot.ninja, that really helps us out. The donate link is up there at the top, and we have Kim Potter Trial landing page is right there as well. So thank you all for joining us. We'll be back in just a few minutes. Appreciate your support, everyone.